Mr. Beer, before we hear from those who wish to make final oral submissions, there's a bit of business that you and I need to deal with. First of all, I have another sad announcement to make, so we'll start with that. And the sad announcement is to record the death of Mrs. Margaret Boston, who died on the 2nd of November of this year. She was a co-participant at this inquiry. She became a postmistress in 1984, and quite shortly after becoming a postmistress, she fulfilled what for her was a dream in becoming the postmistress at the Brex Post Office in Rotherham in South Yorkshire. In 2011, Mrs. Boston ceased that role on the grounds of ill health, but she was succeeded by her daughter and son-in-law, and my understanding is that they still manage or own that post office, so that there has been very many years in which the Boston family has been involved in that post office in Rotherham. Mrs. Boston viewed her work as a public service. So much so that on one occasion she confronted an armed robber and deflected him from his would-be robbery of her post office, for which she received a certificate of bravery from the post office. She also spanned the coming into being of Horizon, so she knew the post office prior to Horizon and she knew it afterwards. And I understand that at an annual general meeting of the NFSP, she spoke up and suggested that the use of Horizon should cease while its faults were worked out. She was a claimant in the litigation proceedings between Bates and the Post Office, and it is of some consolation, I believe, to her family that she had received full compensation via the GLO scheme prior to her death. On behalf of all the members of the inquiry team and on my own behalf, I extend deeper sympathy to Mrs. Boston's family and friends. Mr. Boston has been appointed as a co-participant in place of his deceased wife. Thank you. Over to you, Mr. Beer.
Thank you, sir. Before hearing the statements, the closing statements on behalf of the call participants, may I do two things. Firstly, read into the record an additional 53 witness statements that the inquiry has disclosed to call participants since we were last here at the end of Phase 7 on the 13th of November. And secondly, to make some very short closing remarks. I should say immediately that, unlike the position adopted by some counsel in other inquiries, I and my team do not consider it to be our role to make closing submissions that seek to persuade you of the conclusions which you should come to in your report. We have assembled, called, and tested the evidence. It is not our function to urge particular conclusions upon you. So then, reading into the record. As you know, sir, I commonly undertake this exercise at the end of each phase, and now is a good opportunity to do so, as this may be the last occasion on which the inquiry holds a public hearing. As you explained on the last occasion, although the inquiry will continue to gather, analyse and disclose witness evidence over the coming months, we will not convene hearings simply to read into the record the evidence that has been obtained. Instead, it will be disclosed to call participants and uploaded periodically to the inquiry's public website. I should say that the inquiry does not expect any of the outstanding witness statements substantially to alter the submissions that are about to be made, although if unexpectedly there are any particular witness statements that are subsequently disclosed that might do so, we will carefully consider whether a facility for additional written submissions should be afforded to call participants. Can we please display the PowerPoint presentation INQ 402035? And look at slide 2, please. There are 27 Phase 1 witnesses, and I'll read the names, not the INQ numbers. They are the statements of Alistair Murray and Jana Sethi, Aslam Ramtula, Elaine Illich, 2 anonymous witnesses, James Withers, a 3rd anonymous witness, Sharla Ahmed, Christine Goodwin. Over the page, please. Canas Garundaram Prince, an anonymous witness, Debbie Hall, Marion Drydale, Gary Brown, Gareth and Tracy Etheridge, Terence Seeney, Aaron Benoit, Mahesh Kalia, John Bezic, Nicola Arch, Teresa Lean, Margaret White, Baljit Sethi, Suzanne Palmer, and Rajpal Kaur. May those be read into the record. For Phase 2, a single witness statement, the second witness statement of Anthony Oppenheim. Over the page, please. For Phase 3, witness statements from Lynn Sagar, Nay Fallowfield, Paul Holland, and Kim Riley. Over the page, please, to Phase 4. Witness statements from Dorothy Day, Debbie Atkinson, Kenneth Donnelly, Angus Crawford, Simon Hutchinson, Elizabeth Kennedy. For Phases 5 and 6, there are, I think, 12 witness statements here. Peter Newsom, William Gibson, Sir Jonathan Swift, Amy Prime, Kevin Gilliland, Matthew Shields, Richard Watson, Mike Deaton, Krista Band, Jessica Barker, Gareth Thomas MP, and David Oliver. And then over the page, please, 4 witness statements for Phase 7, Thomas Cooper, Kevin Hollinrake, Jane Davis, and Nick Reed. May those statements be read into the record.
Yes, of course.
Turning to closing remarks, when I made my opening statement to you on the 11th of October 2022, I said that although the underlying subject matter of the inquiry was information technology, the inquiry was not and would not become a dry technical investigation into an IT project gone wrong. That was because it would be an inquiry that was actually about people whose mental and physical health had been impacted, about people whose marriages and partnerships had deteriorated and failed, about people who thought about taking their own lives, and in some cases, who took their own lives. Since that time, we've been engaged in a rather substantial task. We've disclosed 270,785 documents to the core participants in the inquiry. As you've heard me say a number of times, the contemporaneous material has been the lifeblood of the inquiry because it has allowed us properly to test what witnesses have said to us. I'm reliably informed that the page count for that disclosure is 2,214,858 pages. So we've had plenty of material to work with. We have presently obtained 780 witness statements, including disclosure statements, and the page count for that material is 23,928 pages. And we have heard oral evidence from some 298 witnesses, including a wide range of expert evidence. Perhaps the most significant figure, however, does not relate to the work that we have had the privilege to undertake. It's the number of postmasters and former postmasters who have died whilst waiting for the Post Office and government fully and fairly to compensate them, many of whom have been core participants in the inquiry and whose passing it has been your sombre duty to announce with, I'm afraid, tragic regularity. I hope that we as your team have fulfilled the promise that I made at the start of the inquiry to you, not to lose sight of the fact that the inquiry was not to be one into a computer system, but rather an investigation into the harm caused by people to people. It is now for others to help you to marshal your thoughts and your conclusions through the submissions that they now make.
Thank you, Mr. Beer. Right, well, as I think everyone will know, we have allocated effectively an hour to each advocate, apart from one advocate who is limited to 30 minutes. I will have to be reasonably strict about that so that we get through what we need to do in each day. Obviously, there is a vast amount comparatively of written submissions from the people who wanted to make them, which I've been trying to digest faithfully during the course of this last week. And it's obvious that I'll have to read it more than once because they are formidable pieces of work. So I expect that each of the advocates will use their time in order to summarize their main points and, where appropriate, attack points of which they disapprove. So with those very short remarks, over to you, Mr. Henry. I think you're first in the batting order.
The greatest horrors of the world, man's cruelty to man, are not caused by monsters, malfunctions, or misfortune, but by those who claim to act in the name of good, enforcing a perverted vision of order that leaves no room for dissent. Cruelty has a human heart. The truth is that this tragedy, as Mr. Beer has said, is not about an IT system. Horizon did not destroy the innocent. The malignant culture of the post office did. The post office's inveterate contempt for the sub-postmasters, its corrosive prejudice against them, its desire for absolute control over them was the incubator for these terrible events. The seeds of this tragedy lie in the misappropriation of Horizon as a weapon of domination. Voltaire's words come to mind. Those who can make you believe absurdities would have you commit atrocities. The absurdity was the belief that cascaded from the top down, from the board and the executive to the auditors and the investigators, that Horizon was incapable of generating shortfall errors. It was infallible. There were no bugs. And when they were caught in that lie, they used this mantra instead. It was robust, with a few minuscule exceptions or anomalies. The sub-postmasters' plaintive cries for help were dismissed. They were stigmatized as troublemakers, incompetents, or dishonest. And they were then isolated and silenced with a lie. It's you. It's only you. You're the only one complaining about a problem. There's nothing wrong with the system. Such heartlessness came from the top. They did not listen because Horizon was not rolled out to make balancing easier for the sub-postmasters, but as a means to annex their accounts, deprive them of all autonomy, and to exert a degree of totalitarian control. It was as if Horizon was its faithful spy for the post office at every branch and every counter, reporting accurately everything back to HQ. The annexation of their accounts, their being denied access to the constituent data, and ultimately the removal of their right to challenge the figures was a modern form of corporate tyranny. Horizon had become a false god. The atrocities that followed were the inevitable consequence of enforcing that dogma. People were ruined. People were bankrupted. People were imprisoned. There were atrocious miscarriages of justice. People died. Whether the board and the executive knew of these injustices from the start is an irrelevant diversion. They ought to have known or appreciated that by refusing to countenance the possibility that Horizon might generate shortfall errors, they had created a terrible risk. It was a recipe for certain disaster. By the time they realized that terrifying injustices had been inflicted in their name, they had a choice. But they closed their minds and close ranks around the system. There was a culture of contempt, ridicule, even hatred towards the sub-postmasters and their complaints. Former SPADs derided the sub-postmasters' allegations as, quotation, the self-indulgence of a number of malcontents to the detriment of our customers. SPMs and other SPADs said had lifestyle difficulties. So-called investigators boasted of retaining documents in breach of the Data Protection Act, quotation, to prove there's no effing case for the justice of thieving sub-postmasters. They were all crooks. And of course, like all culture, the prejudice was top-down. Paula Venables piously professed her disagreement with the instinct of her predecessor, Alan Cook, when he said that subbies with their hands in the till choose to blame the technology when they're found short of cash. But in 2014, Miss Venables was to write disdainfully, despite, because of course, sir, it was 2014, despite all she then knew, that she was more bored than outraged by the sub-postmaster's complaints. Those who lack interest, let alone curiosity about the world beyond their own notions of order, often lack compassion for others and become devoid of empathy. This typified the attitude and prejudices of the board, the executive, and even Whitehall during this dreadful epoch. It similarly applies to the lawyers, internal and external, who enforce this corporate psychopathy with ingenuity, ruthless disregard for ethical norms, and even deceit. This terrible story reflects badly on almost every aspect of our society and causes us to question everything that we believed in previously about Britain. But you appreciate this already, sir, and I'm conscious that addressing you now at the end of years of evidence is about as useful as me presuming to teach a dolphin how to swim. You know your own mind, and it is not for me to tell you what to conclude or how to think. But you have asked this question more than once. Is the post office worth saving? And to answer that question, I refer to another mammal. Has the leopard changed any of its spots? Whether the post office is worth saving must depend on whether it has changed, or is its character, so often malignant and vindictive, immutable. What is the test, sir? Compensation, righting past wrongs, however belatedly, is surely the yardstick by which you, sir, shall judge whether the post office has really reformed itself. Unfortunately, the conduct of compensation, as you have seen, tells you that the leopard has not changed its spots and remains both cunning and dangerous. Its conduct of compensation reveals that the post office's reprehensible traits are not historic or past, but very much alive and continue to poison the process. The post office's dirty tricks still continue, for all it says to the contrary, because the post office is not what it says, but what it does. And look at what it is doing now. Its technocratic demands for 5 expert medical reports concerning Janet Skinner's disability reflects its adversarial, robotic disdain for its victims. Its heartless rejection of Gowri Jayakanthan's claim for compensation mirrors its cruel humiliation of her late husband. Her entire claim was rejected based on a technicality. It echoes the approach you saw during the GLO steering group meeting of the 11th of September 2017, in which 3 strategies were advanced to, I quote, force the claimants into a position where they give up or settle. One was called thinning the herd, which has a neat, dehumanizing touch, does it not? I quote from the document, thin the herd. We've identified various types of claimant that might be facing procedural problems that could see them struck out. Claimants who are dissolved companies. Claimants who are bankrupt or deceased. The way the post office is treating Gowri Jayakanthan today was foretold in this GLO document, which is now 7 years old. They're thinning the herd. The mindset remains the same. And the Post Office was thinning the herd with its ludicrous demands for contemporaneous documents, wasn't it? Despite knowing that it had locked sub-postmasters out of their own premises, denying them access to their own documents, and even shredding them. This requirement for contemporaneous documents during the compensation process reveals that the Post Office will put up any obstacle to evade, minimize, or delay proper restitution. And that it crafted this process not more than a few months after the Common Issues judgment, which outlined its appallingly one-sided reverse burden of proof denial of documents to the sub-postmasters. The fact that it crafted this process predicated on such demands for contemporaneous documents shows that it continues to manipulate as cynically and as offensively as ever. And you will not forget, sir, that it was a Mr. Underwood who made that calculated suggestion concerning contemporaneous documents to limit applications. I will return to Mr. Underwood later in another context if I have time, but he typifies the mindset of manipulation, and the mindset remains the same. The duplicitous arrogance that animated the aggressive litigation before Mr. Justice Fraser, before a jury at Guildford Crown Court in 2010, and before His Honour Judge Havery, just off Fetter Lane in 2006 to 2007, has now been superseded by a compensation process that is pettifogging, legalistic and cruelly slow. Bogged down by attritional bureaucracy, many claimants surrender, for that is what attrition does. You give up. You take the miserly offer you're given and do not settle for what you truly deserve. People, as we have heard today, have died, and more will die without proper, let alone prompt, redress. They're worn out by schemes that are cynically devised and brutally operated. And so, therefore, some may take the cash, not because it's fair or full, but because they can no longer face the battle. And this is a Dickensian process. Legal technicalities devoid of merit are taken on a whim by the Post Office. You'll have seen in the codicil to our written submissions reference to the grossly unmeritorious clawback ploy the Post Office attempted, which Lord Dyson roundly rejected. These spurious claims were driven by the Post Office's dictatorial belief in its own sense of entitlement. They believed that they were entitled to grasp back these modest sums which the sub-postmasters had agreed between themselves and which had nothing to do with the Post Office. The mindset remains the same. So was this not the behaviour described by Lord Justice Coulson when rejecting leave to appeal after the Common Issues judgment, when stating that the Post Office's application, and I quote, is founded on the premise that it was not obliged to treat their sub-postmasters with good faith, and instead entitled to treat them in capricious or arbitrary ways which would not be unfamiliar to a mid-Victorian factory owner. That memorable phrase sums up not only the Post Office's grotesque imbalance of power, but also its unshakable belief in its own entitlement that continues. The mindset remains the same. You may have been struck, although it's now some time ago, by the Post Office's closing submissions in Phase 3, sir, when addressing the findings of Mr. Justice Fraser, as he then was, in the Common Issues judgment. I shall refer to that as the Post Office's modern slavery approach to contract law, for so it was. Let me quote what the Post Office wrote in that submission, paragraph 29. The Post Office accepts the findings of Mr. Justice Fraser in the Common Issues judgment. Well, I'm sure everybody will be relieved to hear that. But there's a catch. They continue. However, it needs to be recognised that Mr. Justice Fraser's interpretation of the respective obligations of the Post Office and Postmaster were significantly different from the Post Office's genuinely held beliefs at the time, as to what those obligations were. In particular, the Post Office held genuine beliefs that postmasters were contractually liable for all losses at their branch. The burden was on the postmasters to provide evidence that they should not be so liable, which in a sense flowed from the belief as to the postmaster's contractual liability. The belief, they say, at paragraph 30, as to the contractual liability of postmasters is key. Genuine belief. Genuine belief. Genuine belief. As Lewis Carroll once said, why, sometimes I believed as many as 6 impossible things before breakfast. Those troubling submissions reveal a not even grudging acceptance of Mr. Justice Fraser's decision, an almost palpable resentment towards his finding. They bring to mind his comments that the Post Office doesn't tend to focus on the precise words of a contract. It knows what its interpretation is, and that is what everyone works to. This could be described as the Post Office method of contractual construction. And so the Post Office ignored the plain words of the contract. It believed it could do what it liked, just like the clawback ploy, just like its approach to disclosure, just like its belief that it could set up mediation schemes, bring in people to report upon its actions, and mandate the outcome in advance. And so it was then, and so it remains today. The mindset remains the same, and that grotesque imbalance of power, with its willful abuse of privilege, including access to deep, if not bottomless, government-lined pockets, continues to destabilise this process. It is an affront to justice. And while survivors scan their depleted ranks, so many having died, and those who are left surrender for a derisory sum, the Post Office, in contrast with an extraordinary abuse of its material power, yet again racks up millions upon millions of pounds in legal fees, all public funds to HSF and other corporate law firms. It's a shameful spectacle, and it conveys a pitiless, brutal message. And in these circumstances, is it really any wonder that demoralised victims look on, exhausted and aghast, because nothing has changed? 5 years have now passed since Mr. Justice Fraser said, and I quote, "The Post Office appears, at least at times, to conduct itself as though it is only answerable to itself. The statement that it is prepared to preserve documents as though that were a concession, and the obdurate refusal to accept the relevance of plainly important documents is extremely worrying. The parallels with non-disclosure in this inquiry to that in civil trials are glaring. And you may have read in the press, sir, about complaints from the Metropolitan Police that there are still problems with disclosure, where the Metropolitan Police has sought the assistance of the Post Office. But leaving aside issues of non-disclosure, the imperious attitude that Mr. Justice Fraser astutely observed is also relevant. The same arrogance, high-handedness, and inexhaustible funds for attritional lawfare we still see today, not only in our clients' desperate struggle for compensation, but in the Post Office's attempt to control you, sir. Not once, not twice, but 3 times, the Post Office tried to play divide and rule in its attempt to overawe the expert you had nominated and to divert you from decisions you had made. Those decisions of yours, sir, being informed by your own substantial experience in criminal trials and appeals. But the Post Office wanted to hijack the narrative. I refer, of course, to the instruction of Mr. Jonathan Laidlaw, KC, in a happily unsuccessful attempt to manipulate this inquiry, present it with a fait accompli, Laidlaw Volume 1, then ambush you with Laidlaw Volume 2, and then question your decision not to admit that 2-volume report into evidence. But of course, the Post Office knows best and continues to act as if it is answerable to no one. And in fact, you will have read in its written submissions that all it ever wanted to do was assist you. All it ever wanted to do was help you when it did all of those things in defiance of the orders you had made. The mindset remains the same. And so it was when the Post Office claimed that the public interest cases were not to be compensated, despite offering no evidence against them. And so it was the same as ever when it grotesquely singled out, sought to victimize and to defame Mrs. Adedeo, denying her conviction was unsafe under the cloak of qualified privilege. Its atrocious attempt at victimization echoes its past wrongs. Its deplorable behavior tells you that its instinct to scapegoat the individual remains unchanged, that its propensity to abuse both power and privilege still lurks beneath the surface. The mindset remains the same. I've begun with compensation because it demonstrates that the Post Office's wrongdoing is still continuing, not past or historic. The truth is that there is nothing full, fair, or prompt in its conduct of this process, sir. And where victims have not had the benefit of legal representation, they have been further degraded, insulted, and exploited in the most terrible fashion, with token payments for the destruction of their lives. So I return to your question. Is the Post Office worth saving? Only when or if it is safe. It will only be safe if it grasps and understands the nature of its own history rather than continuing to deny it. It can only be trusted when its deeds match its words and when it has restored justice by way of full and fair compensation to those it destroyed. And you have seen that the Post Office and its paymaster shareholder have failed dismally on both counts. So enough, we say, with commissioning reports and strategy papers and endless intangible outputs that waste public money and improve nothing. The victims of its monumental harm deserve to be compensated. They are more deserving of millions than the firms who are paid to fight them. And the evil that the Post Office did was profound. It was the cause, the perpetrator, and the prolonger of the most serious series of miscarriages of justice in our history. And yet still, it plays the adversarial game. Together with Miss Page, instructed by Messrs. Hodge, Jones and Allen, we represent a small cohort of extraordinarily fine, courageous and exceptionally remarkable people who have suffered beyond imagination and who are being re-victimized and re-traumatized in this appalling process. We only represent former sub-postmasters, which has allowed us the freedom to argue that there is absolutely nothing to be done with an institution so blind, so willfully incapable of understanding its own terrible wrongdoing. Our focus throughout this inquiry has been on genuinely attempting to assist you to establish the truth and thereby facilitating future prosecutions of those responsible for these terrible crimes based upon this inquiry's fair, impartial, and unimpeachable findings of fact that you will record in due course. And of course, our other focus, which is why I began with it, is compensation. Unspeakable crimes were committed to convict the innocent. Evidence was commodified. The truth was withheld. And such outrages will only be propitiated by full and fair compensation and by your fair and fearless findings of fact, which will bring with it the restoration of justice and accountability. So I come now to the paradigm cases of Lee Castleton and Seema Misra and the perversion of justice at their trials. They were regarded as test cases by the Post Office to be won at all costs and by any means necessary. Seema Misra's case is of paramount importance, but Lee Castleton's reveals the manipulation and abuse of civil justice of which the Post Office is still capable. The Post Office should have said to Lee Castleton, "We perverted the civil justice system for a collateral purpose. We didn't come after you for the money. We knew the case made no commercial sense, but we wanted a deterrent. We needed a precedent. And in order to get one, we destroyed you and your family. We abused the process of the court when we told the judge we didn't know of any problems and withheld the Coyne-Cleaveley's report. We're sorry. We fought the case on a false basis. We incited or allowed false evidence to be given against you, be it from Anne Chambers or Helen Rose. We admit it, even if they do not. We brought the case on a dishonest basis when we said you'd adopted the accounts. We took advantage of you. We knew you hadn't adopted the accounts. You'd made nearly 100 calls to the helpline begging for help. But we used a clever little legal trick to reverse the burden of proof, to ruin you, your family, and all of your futures, to deter others. What about Seema Misra? We needed another scalp by 2010. Even before Freeths entered the fray, Shoesmiths or Access Legal, Edwin Coe were all breathing down our necks. And so we trod on yours. If we convicted you, we could see off the civil claims and deter others from challenging the system. We knew about bugs. We knew that the receipts and payments mismatch bug ought to have been disclosed to you, particularly as it revealed remote access without branch knowledge or consent. We knew that the jury, according to Mr. Singh, were utterly beholden to Gareth Jenkins and that it was his evidence that convicted you. And, of course, Mr. Jenkins knew all about covert remote access, but he hid that from you too. We allowed false and misleading evidence from Andy Dunks to be used against you. So many people were awaiting the outcome of your trial, and not long after you were convicted, we obtained the transcripts to use in our defense of the civil claims. You were our priceless test case, and it was for that that your freedom was stolen. Your conviction was the so-called shining proof of Horizon's integrity. Your conviction was the cornerstone of our strategy of deterrence and containment. And when we, the board and the executive, found out that Gareth Jenkins had lied, we could not let you know. We could not tell you. The case of Seema Misra is as dark and appalling as anything you have witnessed. It is a microcosm of the wickedness the Post Office perpetrated up and down the country to convict people. But the cover-up brings with it a deeper level of wickedness because it involves the CEO and the chair, and as time went on, countless subcommittees. What the Post Office is trying to do in its written submissions is to distance itself, its corporate mind, from that infamous episode of non-disclosure, and so abdicate responsibility for it. It denies being the cause of this deplorable strategy of suppression. It eschews responsibility for its strategy of containment. Containment was a concerted and coordinated policy involving the upper echelons of the Post Office to suppress knowledge of Horizon's flaws. But it was not only that. It was also predicated on containing civil and criminal litigation risks involving potential civil claims and potential criminal appeals. Impermissible disclosure decisions, perverse and even perverted disclosure determinations were arrived at, influenced by the containment of those interlocking risks, those interlocking civil and criminal litigation risks. And you have seen that non-disclosure in criminal cases to buttress the defence of civil claims is but one example. But in its closing submission, that 103-page document with 804 footnotes that will for posterity attest to the Post Office's dismal failure to face its wrongs, there is no mention of the word containment, the very word the board and the executive used when discussing this calculated, callous, and coordinated policy of suppressing the sub-postmaster's concerns and complaints. It's a word or concept you will find referred to hundreds, perhaps even thousands of times in board and executive documents. It animated the policy of the board and the executive towards the sub-postmasters, yet you will read nothing of it in the Post Office's closing submission. Nor will you find any explanation for why these perverse, even perverted disclosure decisions all go one way in the Post Office's favour and to its adversarial advantage. But there are clues, because although, as predicted, the Post Office wants to blame it on the lawyers, it wasn't just the lawyers. They were only part of the arsenal of containment. Containment extended to undermining the mediation scheme, notorious lies being told in public statements, lies to Parliament, disgraceful, unattributable briefings, the gelding and getting rid of second sight, all the dark acts of misinformation, diversion, and deception. The responsibility for all this lies with the board and the senior executive. And so we say that toxic policy of containment was mandated by the board. And of course, it affected the conduct of both internal and external lawyers. The lawyers were following the path that had been set for them by the chair and the executive. Or they resorted to drafting their terms of reference in such a way that obvious questions need not be faced. For example, and it beggars belief, not to ask the question whether the conviction is unsafe. And so thereby responsibility would be fragmented, mutually delegated irresponsibility, mutually delegated unaccountability. But of course, as you have seen, this involved the misappropriation of civil and criminal justice for the Post Office's own commercial advantage. And by trying to hide behind the lawyers, the Post Office is worthy only of contempt. The misappropriation of civil and criminal justice came from the very top. It could only have done so. One rogue lawyer or other executive may be regarded as a misfortune. 2 looks like carelessness. 3, could it really be a coincidence? 4 or more, sir, were clearly following orders. And it's the culture. The board and the executive saw lawyers and legal reviews as tools for optics. They were interchangeable, malleable instruments for implementing its will. But if the board saw lawyers as tools for optics, it cannot deny knowledge of what those lawyers were doing in its name. In the same way, it cannot say that the flaws about Horizon, the risks about Horizon, were all in a black box in either the IT department or the legal department, an impenetrable black box which they could not peer inside. Nonsense. The fact that they used the word containment imputes knowledge. They knew what was inside the box. They wanted to keep the lid on it, and the lawyers were part of that strategy along with PR to enable them to do so. And that culture, that directed that abusive policy was one that deprecated those who would put their professional obligations before their loyalty to the business. You'll remember that extraordinary note from Paula Venables about Susan Crichton. You'll remember Alice Perkins complaining that Crichton hadn't marked Second Sight. And you'll remember later on under Tim Parker that the board wanted to take potshots at Seema Misra. That is the culture, sir, that you are dealing with. The culture that even infected the law. Because there were expectations. There were embedded commands disguised as questions. In the same way, Paula Venables learnt, so she said, from Alice Perkins, to craft a question as a disguised imperative, which would necessarily result in an outcome of her choosing. So you can see how this attitude polluted everything. I need to say this became the be-all and end-all of everything. Because just like its interpretation of the contract, the Post Office knows what its objective is, and that is what everyone works to. And that included delaying or denying rights of appeal. And you will remember, even in 2018, when there was so much knowledge about Horizon, Mr. Butoy's case was rejected by the Court of Appeal based on the mantra that by that time the Post Office knew was a lie. But the Post Office says it's not our fault. We recruited the wrong people, Cartwright King. We gave Mr. Parsons too much responsibility. But the question, sir, is always why? Why did you pick such unsuitable advisors? Is it bad luck, incompetence, or a lack of integrity? Which brings me to the two questions I put to the Post Office on the 8th of December 2022. Did the Post Office deliberately interfere with or obstruct convicted defendants' rights of appeal? Second, if so, was its purpose in so doing improper? Why was Seema Misra not provided with the information that could have cleared her name in 2013? And I described it as an integrity test. And answer came there none from Miss Gallifant, King's Counsel. And 2 years have passed, and you will not find an answer to those questions in the Post Office's written submissions. The Post Office's abject failure to answer those two questions, which are fundamental to the issues you are inquiring into, shows that it has not learned any lessons from the past. The mindset remains the same. The Post Office scandal is apparently, according to the modern Post Office, a 20-year-long mistake. No one is to blame other than some lowly, obscure functionaries who went off on a frolic of their own, a very long, very uniform, and very coherent frolic of their own. There was no deliberate decision to use Horizon evidence to crack down on dreams of fraud. There was no deliberate decision to suppress the expert report in Cleveland's. There was no deliberate decision to make Lee Castleton an example, put his head on a spike to strike fear into others. And what about Mr. Smith, the managing director? He didn't commission a whitewash. The Ismay report was a genuine attempt to find out whether there was any truth in the claims that Horizon was unreliable. And he, of course, had no idea that the Misra trial was a test case to vindicate Horizon at all costs and by any means necessary. He believed it was a genuine, properly founded prosecution. And thereafter, it was just a terrible mistake that the Post Office didn't realize, particularly the management, that they were covering up hundreds of miscarriages of justice, because no one was deliberately suppressing knowledge that Fujitsu could tamper with branch accounts. No one was deliberately downplaying the fact that there were bugs that could have an impact on branch accounts and create shortfall errors. No one, of course, was deliberately suppressing the knowledge that the Post Office had been relying on an unsafe witness to prove that Horizon was reliable for its landmark case, the only one in which he gave oral evidence, and that the Post Office had failed to instruct him properly. Now, it was just unfortunate that all of these things occurred. And as for the idea of suppressing the Clark advice, well, no. I mean, wasn't it précédé? Wasn't it effectively distilled in the Altman General Review? Well, Mr. Altman, of course, himself says he failed to realise that the Post Office needed to disclose the Gareth Jenkins taint. But the Post Office still says that it did all that it needed to do by disclosing the Altman General Review to the CCRC. And it was evidently the fault of the CCRC that they failed to realise that for themselves. Well, we'll come to the CCRC later. So in other words, this is an outright repudiation of the findings of the Hamilton judgment, which, of course, in turn were predicated on the findings of the Common Issues judgment and the Horizon Issues judgment. And so what the Post Office is doing is saying that the Court of Appeal got it wrong in the Hamilton appeals. There was no affront to the public conscience. There was no unconscionable misconduct. This was just a series of unfortunate mistakes which happened to have a cataclysmic effect on hundreds of convicted innocent postmasters. But nothing was deliberate. There was no orchestration at all. It is a repugnant stance, and it would be astonishing were we not already inured to the absurd malignance of this ungovernable institution. This strategy is a natural extension. It lies in succession with the aggressive and untenable positions taken in the GLO and the Hamilton appeals when resisting Limb 2. And it proves without any doubt yet again that the Post Office will never change because the mindset remains the same. So what you will discover therein instead is a polished, an ever so carefully polished attempt to promote a false narrative, a sustained effort to deny the reality and the gravity of the wicked wrongs it perpetrated. It's all a failure of governance. It's the classic plead to a lesser offence, the governance failures of an inanimate corporate. The board wasn't alive to the risk. The board wasn't in possession of the Clark advices, the Altman General Review, etc., etc. Our systems were suboptimal. The board had nothing to do. The executive had nothing to do with the deliberate suppression of Article 6 rights, which is embodied in the case of Seema Misra. The truth is that human beings engaged in a deliberate conspiracy, first to convict innocent people, either in the criminal courts or to destroy them in the civil courts, and then to cover it up. And by refusing to admit these wrongs, these despicable acts, the Post Office has shown that its words of apology are bogus and that it cannot be trusted. And that deplorable wrongdoing went to the top. Why? Well, because those two questions about why it suppressed Article 6 rights and was its purpose improper in so doing, they lie so close to the heart of this inquiry. And the answer for them can be found in the consequences of telling the truth. Damages, restitution of wrongful millions upon millions of shortfall monies received, loss of compensation awarded by criminal courts, and the reversal of confiscation orders. the damages would have been vast. These were existential risks that had to be contained. Roderick Williams knew that. Roderick Williams, during his telephone call with Martin Smith on the 2nd of September 2013, wrote down 8 words which spelt out the consequences for the Post Office should its wrongdoing ever be revealed, including, of course, that it had dismally failed in its duties as a prosecutor and was far more responsible for these disasters than the unsafe witness that it had failed to instruct. And those 8 words were those that I've already mentioned. Those 8 words were damages, restitution of money received, loss of compensation. This was an existential threat that had to be contained. And Roderick Williams knew that on the 2nd of September, a week before the Altman disclosure consultation. He would have had no reason to withhold that knowledge, that apocalyptic knowledge that he had acquired from Smith about the Post Office's failure to instruct Jenkins. He would have been duty-bound and no doubt anxious to report what he knew to those with whom he worked or instructed. And we say, sir, it is the dissemination of that knowledge which may explain why the Jenkins tape took years to emerge and was avoided, overlooked at the Altman consultation and subsequently. Because you see, on the same day that Roderick Williams spoke to Mr. Smith, the 2nd of September 2013, there is an interesting exchange of emails involving Miss Venables and Flemington, who has forwarded emails to her from Mr. Richardson and Mr. Parsons of Womblebond Dickinson. Now, the Post Office, in its written submissions, doesn't refer to any of those emails. And the reason we suggest is because they would sit ill with the suggestion that the CEO, and therefore potentially the chair and the board, was not fully cited at that critical juncture on the risk of an overturned conviction and the malicious prosecutions that, or the malicious prosecution claims that would follow. What the Post Office is trying to say is that its corporate mind was divorced from and not responsible for that protracted non-disclosure strategy, that almost sadistic strategy of delay that caused needless suffering, blighted so many lives, which was just fortuitously hatched on the 9th of September at the Altman disclosure consultation. But the Post Office at paragraphs 65 and 66 claims that a Horizon Risks advice note drafted by Womblebond Dickinson in August never got to the board, that there was no evidence that it got to the board, that there was no evidence that it was shared with the board or later summarized with the board. And then they say this, quotation, "This may explain," quotation, "why the Post Office appears not to have focused on the real risk of convictions being overturned and claims for malicious prosecution at an earlier stage." Well, there is evidence, but they haven't referred to it. The evidence that showed that the lawyers were telling Miss Venables not to do anything at all that might promote proactive criminal disclosure. The emails that the Post Office have not referred to, the 2nd of September emails that Hugh Flemington forwarded to her from Simon Richardson and Andrew Parsons, said this: they were advising Paula Venables not to conduct a lessons learned review. And she read that advice, and she understood it. And the reason why Andrew Parsons was advising her not to conduct a lessons learned review into, of course, the second site handling. And of course, you'll know from the 2nd of July press briefing to Paula Venables and the board that the board and Paula Venables from the 2nd of July 2013 were aware that Gareth Jenkins had given evidence against Seema Misra. That is absolutely plain from the 2nd of July press briefing in relation to Second Sight, which also adverted to the threat of criminal convictions being overturned, with the risk that James Arbuthnot would press home the point. But let's go back to the 2nd of September. In that 2nd of September email, Mr. Parsons said this: if this review does need to take place at all, then it should be deferred for 6 to 12 months, so as to first allow Second Sight to be managed out and the mediation scheme to be completed. Should the review reveal any concerns about Horizon or branch accounting processes, then the Post Office may be obliged under criminal procedure rules to proactively pass this information to sub-postmasters involved in criminal prosecutions, both ongoing and historic. In particular, recommendations for change could be interpreted as highlighting historic problems that would need to be disclosed. Paula Venables was fully aware of the real risk of convictions being overturned and consequential claims for malicious prosecution. Because of that briefing, because of that email, and because of her earlier acquired knowledge about the Second Sight interim report, which welded Seema Misra and Gareth Jenkins together. But you'll find no reference of those emails, POL 001-46240, Flemington's email forwarding Richardson and Parsons to her, nor POL 001-46243, her response. And her response is telling. This is clear to me. I appreciate you spending time to provide the advice. As you know, I respect the views of our internal team and of Bond Dickinson, and the timing of this is helpful. Orwin, can we speak first thing, please? There is no record of what Paula Venables discussed with Orwin Lyons, but the lessons learned review, like so many others, never happened. This is clear to me. The timing is helpful. In other words, I understand. I get what you're saying, or what you're not writing. We won't go there. Almost identical wording or code to Miss Perkins' reply to the unsafe witness email. All clear and helpful. The timing of this is helpful, of course, may just be a coincidence. But if Paula Venables had been told about Roderick Williams's knowledge, which he acquired that day, about the mounting concerns, the abject failure of the Post Office to instruct Gareth Jenkins properly, then that would make perfect sense. But of course, what is undeniable is that those emails reflecting the view of Womble Bond Dickinson occurred 1 week before the Altman consultation. Should the review reveal any concerns about Horizon or branch accounting processes, then Post Office may be obliged under criminal procedure rules to proactively pass this information to sub-postmasters, both ongoing and historic. Why did the tendrils of Womble Bond Dickinson, the Post Office's civil lawyers, infiltrate, entwine, clench, even, we say, suffocate the criminal disclosure process? Why was Mr. Altman to be walked through the civil implications of disclosure by Womble Bond Dickinson? Why were Cartwright King to be kept apprised of civil claims? So many unanswered questions. But I now go to paragraph 209 of the Post Office's written submissions, where we're talking about the engagement with the CCRC. And at paragraph 209, the Post Office says this: subsequent letters to the CCRC were drafted by Womble Bond Dickinson, including a holding response on the 24th of July and the substantive response on the 26th of July, setting out Pol's proposed course of action, namely Brian Altman's review, Cartwright King's review of prosecutions over the previous 3 years to determine the safety of the convictions, and once such a case is identified, i.e. where there may be issues over the safety to determine the proper approach to be taken. Well, you know that they dispensed with the issues over the safety. And you know, because the Post Office tells you in its next line, neither of these drafts referred to any issue with Gareth Jenkins. There is no evidence, the Post Office says, that this was at the request of the Post Office rather than at the instigation of Womblebond Dickinson. This is desperate stuff. It's risible, playing the limits of the evidence. There is no evidence that this was done at the request of the Post Office rather than at the instigation of Womblebond Dickinson. It is inconceivable, sir, that the executive would not have been apprised of the contents of that letter. And the Post Office, a public corporation that inflicted misery on thousands during this protracted scandal, this country's most extensive and prolonged series of miscarriages of justice, is acting like a teenage defendant charged with TWOC. There is no evidence. But of course there is. It didn't want the Jenkins taint to emerge. It didn't want the Jenkins disaster to come out. And those letters to the CCRC are an embodiment of the Post Office's cynicism, its spin and manipulation. Hugh Flemington, the head of legal, had articulated it well when he said, quotation, "We need to give off the signals that we are proactive, doing all the right things to keep the Attorney General and the CCRC calm. Hopefully, if they see that, they may leave us to it for the moment." And so they brought in Mr. Altman. Sir, may I just check with you about time, because we started a little bit late.
Oh, yes, you can have until 1:45, Mr.
Thank you very much,
Which gives
sir.
you a generous hour.
I'm very grateful. Jonathan Swift, not the puny judge or author of the report, once wrote that laws are best explained, interpreted, and applied by those whose interest and abilities lie in perverting, confounding, and eluding them. It is a savage verdict on the profession of law, but it has an uncomfortable resonance in this inquiry. How was it that a cadre of professionals, no doubt skilled, one indeed eminent, all failed, or so they said, to discern an obvious, indeed invincible avenue appeal for Seema Misra? It takes extraordinary ingenuity, or is it disingenuity, to have denied Seema Misra the ammunition to clear her name from 2013 onwards by not disclosing to her that the credibility of the man who had given the expert evidence against her was, in your words, shot. Hers was a unique case. It was against her alone that Gareth Jenkins had given oral evidence. And when that devastating document, the Clark Advice, was eventually disclosed in November 2020, 11 months had passed since the Horizon Issues judgment and the conclusion by settlement of the GLO proceedings. Is that a clue that might help explain the long suppression of that document? Gareth Jenkins lurked in the twilight of those civil proceedings, a ventriloquist for Dr. Worden, Mr. Goddeseth, Mr. Parker, and perhaps many others, had he not. But his misfeasance was not disclosed in the Horizon Issues trial, and an elaborate unsworn explanation estranged from the truth was offered for his absence. I return to Seema Misra. How can one begin to justify this protracted group error that denied Seema Misra the precious prospect of securing justice in the nearly 8 years following the Clark Advice until the ruling of the Court of Appeal in Hamilton? The most deluded people, as Mr. Warmington pointed out at the end of his witness statement, choose to disregard what they already know. How much knowledge, skill, and practical expertise in the application of the law one would have to compartmentalize, ignore, forget, or overlook to commit such a collective catastrophic failure of judgment. Think of the people in that room on the 9th of September 2013. The combined experience of that room was vast, yet no one spotted the obvious duty of disclosure that would have speedily quashed Seema Misra's conviction. It was a glaringly obvious solution, disclosed to her the prior existence of bugs, and disclosed to her that the credibility of Jenkins was fatally undermined. And if that had been done, one wonders how long it would have taken to bring her case before the Court of Appeal. Not long, surely. And then, of course, if that had been done, the disclosure of the October 2010 receipts and payments mismatch bug issue notes could not have been far behind. They would have been disclosed too in the run-up to her appeal. And, of course, that was the document that revealed unequivocally by the contents of Solution 1 that Fujitsu had the covert capacity to tamper remotely with branch accounts without the permission or knowledge of the sub-postmasters. You will, of course, recall that at the time of her trial, Mr. Jenkins knew that. You will, of course, recall, although he denies it, that Jarnail Singh held that document, the notes of that meeting, in his hands the Friday afternoon before Seema's trial. Had he and Mr. Rob Wilson done the right thing, no doubt Mrs. Misra's trial would have been brought to an abrupt conclusion on the Monday morning with the offering of no evidence. The right thing to do in 2010 was staring them in the face, but they could not do the right thing because Seema Misra's case held the dam for the floodwaters of claimants whose lives have been destroyed by the Post Office's actions. And we know that from the emails of Mandy Talbot, where she said that if they lost the Seema Misra trial, defending those civil claims would be difficult, if not impossible. Those teeming floodwaters threatened to submerge the Post Office. So even though Mrs. Misra ought not to have been prosecuted at all, that document was suppressed. And I regret to submit, but it seems inescapable that the same considerations, the civil crossover claims, the perverse and perverted decisions of disclosure in one being used to support and buttress the defence of the other, is in action in the run-up to that consultation and during that consultation. Because the fact is, doing the right thing by her in either 2010 or 2014 would have meant that there could have been no possible defence to the GLO. And this is a reflection of other aspects of the Post Office's wrongdoing, such as on the 14th of March 2018, although the Post Office denies it, schmoozing the CCRC, Fujitsu, and the Post Office with anecdotal tales that Horizon was all about a dog being caught on CCTV, jumping on the counter, or a man using a frozen sausage to miss key. With these words, the point landed, there was always an explanation. The point landed, there was always a hidden agenda to give the appearance of being helpful, whilst all the time dripping poison in the CCRC's ear. And so we respectfully submit that no one at that consultation wanted to give Seema Misra a ticket for appeal, as Martin Smith said, and the question is why? The prospect of more Misras crawling out of the woodwork was mentioned, a vile phrase, but she, of course, was not a cockroach or a pest, but a human being. But for the Post Office, she represented the cornerstone of their policy, and they knew that if you took away the cornerstone, there would be a domino effect.
That's quite a good place for you to finish, I think, Mr. Henry. And we'll start with the next domino at 5 to 11.
Thank you.
And I'd like to make it clear to everyone that to keep this under control, I am going to start at 5 to 11. So those of you who go out, either return timelessly by 5 to 11 or come back in very quietly, please. I think the back door's now been closed, Mr. Steen, so I'd ask everyone to be ready to listen to Mr. Steen, please.
Louise Dar was a lead claimant in the High Court. She was cross-examined by advocates on behalf of the Post Office for 3 hours. She says this: I was suspended from my post office in Glasgow in 2017 as a result of Horizon shortfalls. My mum died a few weeks later. My father broke his hip 3 months later. As a result, when I was a lead claimant in the Glow litigation, my mother-in-law came from Pakistan to look after the children. That was so I could travel to London with my husband to give evidence to Mr. Justice Fraser. My family and I are going on our pilgrimage, Umrah, to Mecca, in the spring. I'm only supposed to go on this pilgrimage to seek forgiveness in circumstances where I have true good intentions and do not owe anyone any money. Despite being a lead claimant in the Glow, working to try and get the scandal in the media and giving a human impact statement, I am still awaiting final compensation as the Post Office and Department of Business continue to drag their feet yet again. The general public will presume the compensations have been paid as promised and publicised, not knowing that this is not the case. It's just gone quiet in the media. Are we allowed to owe monies to companies and delay without repercussions or hefty charges? No. So why can Post Office, Department of Business, do this to us? So yet again, we are waiting and wondering, will this ever come to an end? As I think we all recognise, sir, this was never a computer problem. This was always a people problem. And it was people who suffered. It was people at the Post Office and Fujitsu who caused the scandal through cruelty, callousness, and connivance. And people are still suffering from the consequences. Our clients have attended the hearings, followed the hearings on the Inquiry Live feed, and they have found the hearings distressing but also enormously cathartic. They take some comfort that the deplorable conduct of people such as Stephen Bradshaw, Paula Venables, Alice Perkins, Angela van der Bogard, Gareth Jenkins, Jarnell Singh and George Thompson, and many others, have been brought into the light. These people form part of the rogues gallery of the Post Office, memorable for their lies and incompetence. From the startup of the Horizon system, sub-postmasters were doomed. The system was never designed to be relied upon for legal purposes. The Post Office imported policies from the last century into an IT system that the sub-postmaster had little access to and was controlled by a third party. the sub-postmaster contract, which had not changed from the paper age, made postmasters responsible for all losses. Like the Titanic, the post office was running full speed ahead, directly for the iceberg, with the sub-postmasters locked in the hole. Now, there was always the danger, sir, that sub-posters might manage to speak to somebody within the organisation and query the shortfalls. And that might lead to financial losses being highlighted that were not due to their actions. But the post office took care of that little problem through the sterling work of the helplines. They told sub-postmasters they were the only one. They were liable for all shortfalls and they must pay up. I recall the aftermath of the judgment in the Criminal Court of Appeal. We'd finished in the court and we were tidying up our papers and moving out of the court into the corridors where all of the client groups were with their families. There was a young woman who was crying in distress. She seemed on her own. I just wanted to make sure that she had someone that could be with her and make sure that she knew where her legal team was. I didn't represent her. What she was saying, and I won't forget, was that I thought I was the only one. That's what they told me. Now, what was the effect of these helplines? Well, it meant that the sub-postmaster paid up out of their own pocket. But also, it had the second effect, that issues being repeatedly raised about the Horizon system were never investigated. There is no accounting for the number of bugs, errors and defects in the system. The High Court judgment's bug table is no more than a tally from the evidence that Mr. Justice Fraser had at that time. That is because sub-postmasters who tried to raise issues regarding difficulties and errors within the system were shut down. And therefore we will never know how many bugs, errors and defects existed in the Horizon system at any time. Even now, the inquiry's YouGov survey tells us that sub-postmasters are still paying off for shortfalls. Now that means that the current truth is that we don't know the full extent of bugs, errors and defects in the current version of Horizon. The system is obsolete and careering out of control. It has no backup, and Fujitsu does not even dare turn it off, as they have no idea what will happen. They then try and turn it back on again. Now, having heard all of the evidence in this inquiry, today we know considerably more about the defects in the Horizon system and the Post Office's cover-up. More than Mr. Justice Fraser learned. But there remain black holes. Now, the first black hole is the issue of the helpline scripts. Our client group say that helpline staff members were reading from scripts and that they, the helpline staff, didn't even appear to understand what they were reading out. Now, we've been tilting at this windmill and asking for the scripts to be produced since the very first hearing in 2021. But here we are in December 2024, and still 3 years on, no scripts. Our clients simply don't believe that they have vanished. The Post Office is an organisation which has buried evidence, peddled the dishonest line about the robustness of the Horizon system, and sought to protect its own reputation above the lives, health and mental health of sub-postmasters, and the Post Office say they can't find the scripts. What a shocker. The second black hole is the sub-postmasters' money. Where has their money gone? Let's be clear about this. The money which would be possible to trace would be money held in suspense accounts, and those would have been verifiable figures held for the purposes of questioning a shortfall. Now, sir, you'll recall the evidence from earlier parts of this inquiry that in about 2003 and then put into place in 2006, the impact programme limited the ability to use short suspense accounts. Mr. Justice Hooper, Second Sight and Dr. Kay Linnell have all walked this path before us. We suggest that during the lifetime of Horizon, these figures in relation to monies put into suspense accounts would have been available. But Post Office has never wanted to look into this issue and have left time take its toll on accessing this data. I won't go on the screen, but I will read out a quote from an email dated the 16th of January 2015 from Christopher Ojar to Alistair Cameron. The reference, just for note purposes, is POL 000 40805. Mr. Ojar says this: as you can imagine, I am concerned we give Second Sight no more information than is necessary to address the narrow proposition that money is missing from an SPMR account, is somehow taken into our suspense account and then appropriated to our profit and loss account. So that's the suspense account. But the money that will be never found is the money used by sub-postmasters to balance the branch accounts. That is when sub-postmasters put their own hand in their own pockets to pay for shortfalls. Let's be clear about this. When a sub-postmaster puts their own money into the branch account, the shortfall disappears because it now balances. That money is untraceable and can only be accounted for in the memories of sub-postmasters who use their own and their family's money to balance a bug-ridden Horizon system. That money, over the many years, will be in the very many, many millions and would eclipse even the guesstimate figure of 37 million given by Mr. Reid when he was asked by us about this. And it's important to understand that the sub-postmasters we represent believe that they kept the post office going by subbing the post office for the shortfalls in the past and to date. And because of this, sir, they do not accept the term compensation scheme. The financial restitution schemes are giving them their money back. Now, of course, we all recognise, and properly so, that the schemes are about providing compensation as well. But for our clients, the schemes are about getting the money back stolen by the post office. As Sir Alan Bates put it, the schemes are really about redress rather than compensation. Now, so I don't have the time to go into the torturous and painful history of financial restitution and compensation schemes, and so you know it all too well. From the start of this inquiry, you have devoted very considerable time and trouble in calling for evidence and keeping abreast of the various schemes. You have even taken the unusual step of delivering an interim report on compensation. It is no coincidence that over and over again, the very existence of a hearing date on compensation has led to remarkably timely and positive announcements of changes in those schemes. The progress of the financial redress schemes is something for which the inquiry process must take some credit, yet no amount of money can turn the clock back and return what would have been the best years of our clients' lives. Maureen McKelvey from Northern Ireland says this: I was the sub-postmistress at the post office branch in the village of Clannabogan in Omagh in Northern Ireland from 1990 until 2001. My husband, myself, and our family were respected within our community, and family reputation is very important here. I had worked for 10 years without any problems, but as soon as Horizon was brought in, money began to disappear from the branch account. I was suspended in 2001, charged with false accounting. I had to wait 5 long years before the case came to trial in Dungadden, where everyone knew me. The trial lasted a week. The Post Office prosecution took a sample of transactions from days when there were shortfalls to prove that I was a thief. However, on some of those days, the Post Office area manager was running my post office. As I was at the hospital with my son, who had been injured in an accident, I was acquitted. And the local press were waiting for me on the steps of the court where I hoped to state my innocence. However, 2 Post Office security people took me by my arms and escorted me to my car and warned me that I was not permitted to speak to the press. My family's reputation in the local area was wrecked, even though I was found not guilty. I lost my business, I lost my health, I became dependent on others, and I was forced into an IVA. I lost myself. Almost 20 years on, I applied for compensation through the Post Office's historical shortfall scheme. The process has gone on and on and on. I met Nick Reed and Simon Rickalden in Belfast in June of 23. I've travelled to London repeatedly to the Business Select Committee and to see you, sir, and your inquiry. But perhaps, she says, perhaps the worst thing is I'm a proud and reserved woman. I've always made my own way in life, but I've been made to feel like a beggar with my hand out, waiting for compensation. When what I really want is the years that were stolen from us. The hearing dates in this inquiry have come to an end, sir. Now the inquiry goes into a period of reflection on the evidence, drafting, the maximalisation process, and consideration of recommendations. Now, we are at this stage, the close of evidence, government and Fujitsu, and the Post Office. They seek to breathe a sigh of relief that the inquiry's dogged determination to hold them to account and to a timely timetable has gone away. But there are still steps that can be taken by the inquiry to continue to hold the government, the Post Office, Department of Business and Trade to account. For example, in the infected blood inquiry, Sir Brian Langstaff recalled the inquiry before the final report was delivered. He recalled the inquiry on the 26th of July of 2023. To hear evidence from Mr. Sunak, Ms. Mordaunt, to ask them in public what was happening with the compensation scheme for those people infected through the contaminated blood scandal, and when would that compensation start to flow. Further, after delivering the infected blood inquiry report, Sir Brian Langstaff has retained his inquiry powers, agreeing with submissions that we made, or I made, on behalf of my client group in that inquiry, that Section 14 of the Inquiries Act 2005 gives the chair a discretion to continue to fulfil the terms of reference after delivery of the report. Sir Brian took this course after considering the precedent in the SOA inquiry chaired by Sir Michael Bichard. Now, Inquiries Act 2005, Section 14 states, under the heading End of Inquiry, subsection 1, for the purposes of this Act, an inquiry comes to an end on the date after the delivery of the report of the inquiry on which the chairman notifies the minister that the inquiry has fulfilled its terms of reference, or on any earlier date specified in a notice given to the chairman by the minister. I'll repeat that. For the purpose of this Act, an inquiry comes to an end on the date after the delivery of the report of the inquiry on which the chairman notifies the minister that the inquiry has fulfilled its terms of reference. The terms of reference for this inquiry contain no limitation of time, other than a professed aim to report by the autumn of 2022. So I suspect you won't make that date.
I'm sorry to be smiling, Mrs. Steele.
So it follows from the wording of Section 14 that an inquiry does not end with the delivery of the report, but with the chair's, in this case, sir, yours, notification to the minister that the inquiry has fulfilled its terms of reference. The terms of reference of this inquiry at D state that the inquiry shall assess whether the commitments made by the Post Office within the mediation scheme, including the historical shortfall scheme, have been properly delivered. Properly delivered. Those terms of reference were set in mid-2021. Time has moved on. And we know that this scandal has led to the establishment of a number of schemes. We suggest, sir, that the terms of reference of this inquiry must be read in the light of all of the schemes established to provide financial restitution and compensation. And that in order to fulfil the terms of reference, the inquiry must ensure that they have been properly delivered. As a matter of importance, we ask that the inquiry adopts the approach of Sir Brian Langstaff and retain oversight of the content of the compensation redress schemes and the progress of any reinvention of the Post Office to fulfil terms of reference at F, which states to establish whether current controls are now sufficient to ensure that failing leading to the issues covered by this inquiry do not happen again. And so your terms of reference are peppered with points that relate to whether the procedure, processes and information provided by the Post Office to postmasters are sufficient, in other words, sufficient at this time. Whether current controls are now sufficient, it says. We make this request, sir, because our clients do not trust the Post Office or DPT because they believe that they will revert to a litigious approach within the redress schemes and when the process of this inquiry concludes. We suggest they're right to do so. Anna and Bharat Dalal and others are now having to start to fight all over again to make the department understand the underlying purposes and principles of the financial redress schemes. Sadly, this week, just this last week, on the 9th, we have more evidence, or we have evidence of difficulties happening yet again in the attitude and approach being taken by the Post Office. So you'll recall that on the 19th of June of this year, it became clear that the Post Office had leaked the confidential data of all of the 555 Postmaster Glow litigants. That data leak was not limited just to their identities and locations, but also disclosed other personal matters. The data breach re-traumatized almost all of the claimants and exposed a considerable number to further significant harm. Almost all of those affected instructed the key firms who have been assisting postmasters in relation to financial redress and compensation, that's Howe & Co, Hudgell Solicitors and Freeths. The Post Office accepted liability in August. Last Thursday, representatives from Howe & Co, Hudgell and Freeths, met with representatives of Post Office Limited. However, so negative was the Post Office stance that after 3 hours of attempts to make any form of headway, the representative of all three firms were forced to walk out with nothing to show for their efforts on behalf of their clients. So it seems that the 555 members of the Glow litigation group will now have to return to court once again to challenge Post Office, because fundamentally, and I note Mr. Henry has taken the point about leopards can't change their spots, but fundamentally the Post Office is a tiger that can't change its stripes. The Post Office can't be trusted to act fairly when it comes to sub-postmasters. They cannot be trusted to prioritise the issues. So we ask that in addition to the inquiry adopting the approach taken in the Soame inquiry and the infected blood inquiry, the inquiry should continue to scrutinise matters relating to the financial redress schemes through requiring that every 2 months, matter for you, sir, to consider how often, through requiring that every 2 months the remediation unit and the Department of Business and Trade must report back to the inquiry and Select Committee at the House of Commons in relation to progress. And so we also ask that there is an avenue for sub-postmasters to comment on progress. I've been thinking about this, about the burden that you have. So, trust, it's a weight, isn't it? As lawyers and judges, we all want to be trusted, but once we have trust, it's hard to put down. Trust becomes its own duty, and it's a hard taskmaster. So you have the sub-postmaster's trust. You have that burden. We know its weight. We ask that you consider the points that we have made in our submissions, both written and oral today, in looking at both the purposes of the terms of reference, whether they have been fulfilled, but also obviously retaining oversight of compensation matters. We know that you're going to have a busy new year. And so we thought long and hard about how far we should be requesting this additional burden. But sub-postmasters, they ask it of you. And we consider on their behalf that it's right that the inquiry does so. Now turn to restorative justice. We cannot express enough the importance of restorative justice to the inquiry process. This issue was raised in relation to this inquiry by my instructing solicitors Howe & Co. as early as December 2022, and the issue appears to have been accepted by the Post Office. Now, restorative justice is important because it can plug the gaps in financial redress schemes. The evidence of Simon Recaldin on the 4th of November 2004, this year, he accepted that there is no provision in any scheme for family members. Many of those family members have suffered, he agreed, from intimidation, harassment, bullying, educational disruption, as a result of the actions taken by Post Office against their parents or spouses. Restorative justice will also help the individual sub-postmasters and branch employees who were all so badly hurt and damaged by the actions of Post Office and Fujitsu. The measures proposed by Howe & Co. back in December 2022 include ongoing psychiatric and counselling support for sub-postmasters and their families, bursaries to assist with the retraining of sub-postmasters and for the education of their children whose education was disrupted by the scandal. A tangible memorial to mark this largest miscarriage of justice in British legal history that sympathetically records the experiences of sub-postmasters and how profoundly they and their communities were failed by this scandal. We suggest that the Post Office Museum in London might be an appropriate venue for such a memorial that should obviously be devised principally and mainly by sub-postmasters. And what about restoration of reputation? In many cases, sub-postmasters' reputations were trashed in their local communities and regionally. Sub-postmasters' reputations must also be restored within their local communities through engagement with those communities and the local press. In addition, we proposed an entrepreneurial fund, and a fund for affected family members was proposed in the questions we asked of Mr. McAldrin. Now, so you're aware from the recently published report by the In Your Own Words listening project of this inquiry that 65% of people affected by the Horizon scandal have said that their family and relationships were affected. Furthermore, it was a striking feature of the human impact hearings that the stigma which sub-postmasters faced as a consequence of post office actions endures in a significant number of cases. Marion Holmes from England says this: "Sir, I gave evidence to you," Marion Holmes, who is here today. "Sir, I gave evidence to you when you came to Leeds. I had a picture of Peter with me for support. You noticed the picture and asked to see it. Thank you." Peter was a policeman, a good husband, a father. He was also a postmaster, and later a post office manager. Everyone in Jesmond knew him. When I met you, I showed you a letter that Peter wrote to the post office on the 13th of June 1999 regarding the new Horizon system. Peter wrote of how appalling the training was on the new system and how the trainers were learning as they went along. He said that balancing on a Wednesday night now took 5 hours, when previously it had taken only 1. He said in that letter that he was prepared to go anywhere, night or day, even on a Sunday, just to get better training on the Horizon system. He finished his letter saying that he no longer slept beyond 4 a.m. and felt ill at ease going to work. He said that if the post office would not give better training, he would resign in July of 1999. He didn't resign, but as ever, he soldiered on. 10 years after writing this letter, Peter was convicted of false accounting. Peter's conviction was reported in the local press. As a former police officer and post office manager, Peter was very well known in the community. It was devastating to him. He was left a mere shadow of the man he had been. 13 years after his conviction and 5 years after his death, I was at the Court of Appeal with my son when Peter's conviction was quashed. Such a pity he did not live to see it. I think that 3 groups are responsible for this scandal: the Post Office, the government, and Fujitsu. They should all be held responsible when this inquiry is over. I think that they will all carry on as before. Please, sir, don't let this happen. Let me turn to Fujitsu. Fujitsu say at paragraph 3 of their closing written submissions that they fully accept their share of the failings which brought about these appalling miscarriage of justice. Fujitsu's Mr. Patterson appeared to accept when he first gave evidence that Fujitsu may have a wider role in supporting schemes which would assist family members of those impacted by the scandal. However, and conspicuously, Fujitsu have failed to take any steps towards implementing any scheme. By the time, at our urging, Mr. Patterson returned to the witness box, he claimed in answers to me, in my questions, that he and Fujitsu had no experience in devising such a scheme. So therefore, we address ourselves via this inquiry to the board of Fujitsu in Japan. For a multinational company of the size and value of Fujitsu, a failure to do nothing for sub-postmasters other than hide behind your third-party legal status to avoid financial liability is shameful. And so I'd like a document to go on the screen, please. RLIT 40350. So this document is a document that is described by Fujitsu as the Fujitsu Way. and sadly we suggest that they have lost theirs. This is Fujitsu's claim to hold itself to high standards. On page 1, you can see the Fujitsu Way comprises 3 parts: our purpose, our values, and code of conduct. Our purpose indicates why Fujitsu exists in society. And can I turn now to page 3? Thank you. We see they're under trust. Fujitsu honors promises and exceeds expectations, acts with ethics, transparency, and integrity. And scrolling down, please, under empathy, same page. Listens to all people and acts for the needs of our planet. Generates shared value for our people, customers, partners, community, and shareholders. In other words, Fujitsu professes to hold itself to high standards. Sadly, we suggest to the board of Fujitsu you are not honouring trust and exceeding postmaster or anyone's expectations. You are not acting with ethics or integrity, and you are definitely not generating shared value for people, customers, partners, and community. If you claim you have learned lessons and are sorry and want to make amends, then empower Mr. Patterson, the European Director of Fujitsu, to do so. Establish, we suggest, this is not the only route, establish a beneficial trust with sufficient funds to support the families of sub-postmasters in entrepreneurial pursuits, to assist with their education and potentially offer work experience. If your lawyer's advice is that this could be seen as some sort of admission of direct liability to sub-postmasters, it is not. Instead, this could be the start of something great. This is an opportunity to make something good arise from the ashes of this scandal. And it would support the restitution of Fujitsu's good name. Let me take it off the screen, please. Thank you. So what of Horizon now? Mr. Patterson was referred on the 11th of November to document dated the 15th of December 23 from Mr. Walton, the head of the Post Office account of Fujitsu, to Mr. Brocklesby at Pole at Post Office. I'll give the document number, I won't put it on the screen. Again, just for the note, FUJ 00243299. That note contains the following passage. Post Office has historically been strategically focused on alternative solutions to Horizon rather than investing in the existing infrastructure. Due to the age and consequent end of life of service, due to the age and consequent end of service life status of the underpinning Horizon infrastructure, there is an increasing risk of the failure of the infrastructure that could result in adverse impact in the delivery of services to the public. Now that and other letters from Fujitsu to the Post Office tells us that Fujitsu are saying that the Horizon system is now obsolete and increasingly likely to fail. The Post Office has not kept its house in order, and the Horizon system is as much of a loose cannon now as it was at what might be said to be the height of the scandal. But apparently the Horizon system may be used for years to come. And no wonder Fujitsu are keen to get it off their hands in the way that is suggested by the NBIT proposal. Takes it out of Fujitsu's arms and into the Post Office. But we suggest that NBIT system is wrong-headed, and it seems wrong-headed to our client. It doesn't address the problems of the past and just brings the existing Horizon system in-house. Now turn to the question of the Post Office's strategic review, which I will ask to go on the screen. So this is the Post Office's strategic review, strategic transformation plan. It has this reference, POL 00462532. Thank you. Turn to page 9, please. This was available to the call participant teams on relativity, sir, from, as far as we're aware, the date we can find is the 7th of December 2024. This review, as we see on the screen, seems to turn on a £1.8 billion investment requirement over the next 5 years. And page 13, please. You'll see there under strategic imperatives, New Deal for sub-postmasters, or PMs. Create a sustainable, fair and attractive proposition for postmasters that reflects their vital role in delivering post office services. And the review does contain, sir, a recommendation of a significant increase in postmaster remuneration. But this review, we suggest, falls far short of a strategy which reverses the polarity of the post office, as, sir, you'll recall the evidence of Mr. Elton. Now, sir, we request, because of the timing of the publication and the need to take instructions, that we have some more time to make some further written submissions on this document, and no doubt other documents of its ilk will be produced in response by government. Our recommendations in relation to the future of the post office, if it is allowed, frankly, to continue, to protect postmasters in the future include these: a guarantee of a living wage, whistleblowing rights established through legislation, an institution, the post office, listening and investigating, and a chief inspector of the post office and other arm's-length bodies to consider their operation, the welfare within the post office of sub-postmasters, employees and workers, and the maintenance within the post office of its social purposes and intent. I provided you so far, sir, with the thoughts and reflections of our clients from England, Scotland, and Northern Ireland. Let me turn to Wales. Pamela Locke says, I became a postmistress in Swansea in '74. My husband Geoffrey and I ran a successful post office, bakery and shop for 25 years. We'd begin work at 1:30 a.m. and work till 5 p.m, going to bed at 8 p.m. We were proud of the business and of the community we served. Everyone knew us. We worked without a single problem until the introduction of the Horizon system in 2000. Within 7 months of Horizon coming in, we had shortfalls in excess of £30,000. Within another year, I stood numb before the Crown Court in Swansea, pleading guilty to false accounting. My daughter was crying, my husband was very quiet, my paralysed son was there in spirit. On my way home from court, the headline of the front page of the South Wales Evening Post showed my picture and told the world I was a criminal. Geoffrey and I retreated into our cells. My husband was a very private person. He didn't say a lot, but he felt deeply. The following years and decades were very hard. We lost our home that we worked all our lives to buy. We had to go to the council office to beg to be housed in our old age. Eventually, we were offered a one-bedroom flat in sheltered housing. When the Court of Appeal quashed my conviction, I cannot describe the relief of having my conviction overturned and to get my good name back. But it cannot make up for what we have suffered over those 20 long years. Not one person has been held to account for my wrongful conviction or the wrongful convictions of the scores of other sub-postmasters. Anyone with eyes in their heads could have seen the problem must lie with the new computer system. How could a woman work as a postmaster for 25 years without problems of any kind and then suddenly change and become dishonest and inept? I'd like the Post Office to pay for a front-page advertisement in the South Wales Evening Post showing a picture of me then and now with the headline, Pamela Locke was innocent. Post Office apologises. Now, sir, as you know, we have a large client group, and we can see, because of that group, trends and patterns within the scandal. 49 of our clients were expressly told they were the only one. 43 were told by the helpline that they should pay for the shortfall, and 35 of these say that the helpline told them that they must pay because their contract required them to do so. 61 of our clients were threatened with prosecution. 26 were threatened with action in the civil courts. 95 say they were not properly trained to use the Horizon system. And 19 actually experienced shortfalls while they were being trained. Now, those figures come from come from 102 clients, of which we asked, which responded to our questions in that regard. 51 of that 102 say they were ostracised by their local communities. 18 were made bankrupt or subject to an IVA. 41 found themselves in desperate financial circumstances, and 23 suffered from marriage breakdown. Our clients routinely talk about suicidal thoughts, suicide attempts, and ongoing mental health problems. Let me turn to the Post Office's prosecutors. We have said that Mr. Clark and Mr. Altman, King's Counsel, and others did not act appropriately in relation to the Gareth Jenkins issue because their roles as advisors to the Post Office and their duties as prosecutors became blurred. The entirety of the Clark advice, dated the 15th of July 2013, should have been disclosed to all those who had been convicted of offences which included the use of evidence from Horizon. Statements from Mr. Clark and his colleague who investigated the Jenkins issues should have been made. The recording of the call with Mr. Jenkins should also have been disclosed. The police should have been called to investigate what was believed to be perjury and an attempt to pervert the course of justice by Mr. Jenkins. Mr. Jenkins had been the main go-to Fujitsu witness who was used by Post Office lawyers as an expert, despite the failings in his instruction. But Mr. Jenkins was also a principal architect of the Horizon system. In other words, he had been a designer and bug investigator and bug resolution engineer from inception of Horizon. The lawyers on behalf of the Post Office, which included Cartwright King, Mr. Altman, Post Office Executive, Mr. Clark, and General Counsel, knew that Mr. Jenkins was believed to have committed serious criminal acts, and that he was also a mainstay of the system. That put into doubt his evidence at any time, as well as the reliability and digital integrity of the legacy Horizon and Horizon system. Bugs emerging in 2013 included bugs in legacy and online system. It also means that the question of the timeline for consideration of appeals before and after 2010 should have included all Horizon cases, not just then. Now, Mr. Altman was asked a number of questions, obviously, by Mr. Beer about this, and he accepted that it should have been disclosed. That's the material in relation to Mr. Jenkins. Yeah, I'm accepting that, said Mr. Altman. Another piece of the jigsaw puzzle as to why this all occurred in relation to the criminal lawyers can be found in the conference notes in September 2013, again for the note, INQ 401143. Mr. Altman is then recorded as saying, "Can't avoid possibility miseras may crawl out of the woodwork." Now, Mr. Altman went on to prosecute, or he would say, respond in the Court of Appeal. And he worked on the question of whether abuse of process applied to all appellants, resisted some appeals successfully, argued which limit of abuse of process should be applied to which case, and in doing so, obviously, the blame was directed at the Post Office, but failed to mention his own part in disclosure failures. Now, of course, Post Office was centrally to blame, but the duty to ensure disclosure was plain as a pikestaff to all criminal lawyers, of which he was one. They hadn't pressed the disclosure button or called the police, or indeed it seems in reality sought instructions to do so. And by that point, Mr. Altman was a witness to those past events. and he and others, and other witnesses, such as Mr. Clark and other people at Cartwright King. But at that time, in the Court of Criminal Appeal, the finger was pointed solely, it seems, at the Post Office rather than the work of the lawyers engaged. So how did this happen? How did this failure, which was not just the mistake and failure of one individual, but failure of a number of criminal lawyers? Perhaps we have something of an answer from Mr. Clark when I asked him these questions. So when you were providing the advice to the Post Office in relation to Mr. Jenkins, look, there is this massive problem. Really, it's a problem. Was that to a private client? Mr. Clark said yes. We suggest that Mr. Clark is right. He and others failed in what any other scenario would have been their simple operation of their duty as prosecutors in relation to disclosure, recognising the obvious that the Jenkins material must be disclosed and an immediate investigation launched by the police. The failure was because by the point that they were engaged, they had become company men. In future, no lawyer who has any part in the process of prosecution should ever be allowed to divorce their responsibilities in relation to prosecutorial duties and their advice to the entity who instructs them. We suggest the legal regulators, the Bar Standards Board, SRA and ILEX, responsible for advocates before the courts, consider these questions and put in place clear regulatory guidance that puts the prosecution duty first. This inquiry has highlighted important issues surrounding the use of computer data in the courts. In our written submissions, we've asked and suggested a recommendation that the Law Commission reviews the current position in relation to the presumption of regularity of mechanical instruments, the term used in the Law Commission going back now some time. And that courts have regard to the problem that the absence of evidence that there is a software bug is not evidence of the absence of software bugs. That needs to be done through the provision of detailed prescribed information where relevant in proceedings. It would be intolerable, sir, to our clients were the courts to carry on acting on a presumption that computer-produced evidence must be reliable unless the contrary is proved, which is the current position. Bugs, errors and defects will always be present in IT systems. They may not be readily apparent or even visible to those accused of crimes or having actions taken against them in the civil courts, where there is the intent to rely upon the product of an IT system or computer data. Now, so this is relevant to the terms of reference, because we know that in the future, in whatever guise the Post Office continue to operate, there will be an IT system. There will be Horizon 3 or 10 that will be in operation, and that system will be used in relation to the ongoing work of sub-postmasters. And so there needs to be some consideration, we respectfully suggest within the report, of how such data can possibly be used when there is a presumption that it is correct, which is currently in operation in the courts. Now, so you've seen our submissions in relation to whistleblowing in our written submissions. Effective whistleblowing policies would have given sub-postmasters a chance of bringing this scandal into the open much earlier. But it is apparent to us and many other commentators that the law regarding whistleblowing has not caught up with a variety of ways that individuals work. We ask that the inquiry recommends that legislative changes are brought about to ensure that sub-postmasters, NEDs, and others working outside the traditional employment contract are protected. We submit that whistleblowing protection should be extended to all those in the workplace who may see wrongdoing and may suffer as a result of raising public interest concerns. The definition of worker in section 43K of the Employment Rights Act 96 is already different for whistleblowers than other areas of employment law, and there are sound public policy reasons to extend it further. It is important, we suggest, that the inquiry recommends that the Employment Rights Act 96 is amended to include sub-postmasters, non-executive directors within the category of workers that are protected under the Act in relation to whistleblowing rights. I would now like to talk, and very briefly, about the unsung heroes of this terrible scandal. Those individuals are well known to the inquiry. Lord Arbuthnot, Second Sight, Dr. Linnell, her partner Barbara, Computer Weekly, which picked up the scandal, brought it to the attention of the public in 2009. Nick Wallace, whose podcasts and book have provided a journalistic narrative which has been of enormous help and assistance to all those who have wanted to know more about what has actually happened. And of course the producers of the ITV documentary Little Gem, which exploded the story of the sub-postmasters into the public consciousness and shamed the government into taking the sort of urgent action that Private Eye, Computer Weekly, Lord Arbuthnot and many others, including obviously Sir Alan, have been campaigning for many years. Let me conclude, though, my submissions today by returning to the most important people in the inquiry, the sub-postmasters, assistant sub-postmasters, branch employees and their families. We think, obviously, of all the people that we've lost, including Mr. Holmes, the former policeman I spoke about earlier, a thoroughly good and decent man who didn't live to see his conviction overturned by the Court of Appeal. I reflect upon Stanley Fell, a sub-postmaster of the previous century who couldn't cope with the business side of his branch and who couldn't work Horizon, whose appeal was dismissed by the Court of Appeal, but whose fight continues. He died last year. It is heartbreaking that so many of our clients who were with us in 2021 have not lived to see the end of this inquiry process. This includes Carol Riddell, Isabel Wall, Thomas Brown, and of course, as you mentioned earlier, Margaret Boston. Many of our clients' partners have also died since the inquiry began. These are people who suffered with their husbands and wives, and their reputations were also destroyed. These include Veronica May, the beloved wife of Francis May, Fiona Wybrow, who was a sub-postmistress and whose interests are represented now by her husband, Brent Wybrow. Now, sir, we thank you and the entire inquiry team for your hard work and dedication. We thank you, sir, for your time and trouble and patience and frankly, tolerance of their counsel. We thank the solicitor of the inquiry, all those people, our transcriber, document handler, and of course, Miss Pilgrim, the wonderful arrangements that have been put in place to allow this inquiry to continue so seamlessly. And we thank you, sir, for listening to our submissions today.
Thank you very much, Mr. Steen. I make it 11:52, so we'll start again at 12. Is that all right with you, Mr. Malone? Well, you'll have your hour, even if we have to go on till 5 or 10 past, so don't worry about that. We need to have a slightly longer break, all right? So we'll start again at 5 past. What was the time? We just about dead on? We're a minute early, Mr. Maloney, so we let the people come in.
Thank you, sir.
I think they're all in the room now, so could we have some quiet for Mr. Maloney to start, please?
Thank you, sir. So this inquiry is the latest step in a long, long search for justice. A group of people came together to put right a terrible wrong perpetrated against them by the Post Office, a wholly state-owned institution. The impact of the events which sit behind this inquiry were undoubtedly life-altering. Homes and families lost and broken, savings and prospects destroyed, stability and health ruined, reputation and dignity irreparably damaged. Some did not live to see their conviction overturned. Julian Wilson, for example, is now represented by his wife, Karen. She had his photograph with her when she gave evidence. He was one of the shoesmith's claimants all the way back in 2011. Moreover, very sadly, some died while evidence was being heard and are now represented by their families. Indeed, the inquiry is announced and mourned, name upon name, during its course. Lynette Hutchins, Robert Boyle and Gillian Blakey, to name but a few, and very sadly today, Margaret Boston. As we did in our opening statements on the 13th of October 2022, and as we've done at the closing of each phase, we reiterate the value of this inquiry's work for those we represent. Through 3 years of work and many, many hours of evidence, the core participants we represent have followed the inquiry. Many have attended in person, others have watched at home, others still find it too painful to hear the minutiae of the scandal which stole their lives. Yet for them, its work is crucial. Each of our clients is grateful for the work of all the inquiry team, everyone involved in the proceedings, from you, sir, and your assessors, to counsel and solicitors, from the ushers and the shorthand writer to the staff here at Aldwych House and at the IDRC. All have treated the postmasters with dignity and care, and this inquiry with the seriousness it deserves. We and our clients are grateful. It was Tim Brentnell who said in his evidence, first referred to at the end of Phase 4, Horizon merely provided the data that showed a shortfall, but it was people who chose to believe that data over myself or hundreds of other sub-postmasters. It wasn't Horizon that prosecuted us, it was the Post Office. It wasn't Horizon that encouraged us to pay back money under threat of theft charges, that was people at the Post Office. The same Tim Brentnell now says of the people who have worked in this inquiry, the inquiry team deserves enormous thanks. They considered us at every stage and tried to help us attend and make sure our concerns had been met and have all been as helpful and accommodating as possible. Our submission today deals with 6 main topics. First, we look at phases 5 to 6 and the years upon years spent by the Post Office, supported by Fujitsu, in their unblinking defence of Horizon and their prosecution practices. Second, we consider the last of the evidence heard on investigations and prosecutions. Third, we look to the role of regulated legal professionals in this scandal. Fourth, we look at management, governance and oversight. Fifth, we turn to redress, restorative justice and rebuilding trust. And sixth and finally, we ask where we are now as the inquiry ends. Before dealing with each of those topics in turn, in this introduction there are 3 initial propositions we invite the inquiry to consider. First, our core participants are very conscious that this inquiry may not be the last step in the process of accountability. The Metropolitan Police Service is a core participant and continues its investigation concerning possible criminal offences arising from this scandal. While not for this inquiry to determine any question of civil or criminal liability, this cannot inhibit the inquiry's duty to reach conclusions on the facts and make recommendations within its terms of reference. Second, on knowledge. A key question has always been who knew what and when. This must include individuals who were purposefully shutting their eyes when faced with evidence that ought obviously to have been explored. This included failing to confront risks and failing to tell people about those risks. The evidence supports that throughout this scandal, structural problems at both Post Office and Fujitsu aside, there were people within the business who knew or were reckless to the truth or were willfully blind when confronted with the possibility of failures in the integrity of Horizon, and that Post Office prosecution practices were deeply flawed. Horizon was seen to be too important to fail. Thirdly, while explanations may properly be offered, we urge the inquiry to carefully scrutinise any conduct which may have contributed to this scandal. For example, first, on individual memory. The events in this scandal span decades. The inquiry was familiar with how the law approaches evidence and memory. Calls for caution inevitably and reasonably echo in earlier submissions. The inquiry has substantial contemporary documentation against which it may test recall and faulty memory. Those we represent have found it surprising when some witnesses with a vague recollection are suddenly sharp in their recall of conversations or meetings that put them in a good light. The excuse, "I was poorly advised," after decades, is no excuse when the questions they asked were skewed or advice ignored or obvious matters left unpursued. And "I wasn't told," which may provide an explanation for some, is insufficient when the culture of the business was set from the top to deny any possibility that Horizon was flawed or that the prosecution practices of the Post Office had operated egregiously for years. Fourthly and finally, but importantly, any suggestion that the inquiry must identify the villain of this piece as either Fujitsu or the Post Office draws a false premise. Both have their explaining to do. We've heard apology upon apology, and we anticipate further contrition to come at the conclusion of the inquiry. However, after decades of dogged resistance to hear and see the problems they were causing, these are difficult to hear. They are especially difficult to hear alongside mismanagement of disclosure in this inquiry and evidence which suggests that for 5 years since the judgments in the GLO, both Post Office and Fujitsu have remained slow to recognise the scale and significance of this scandal. They are difficult to hear alongside witness upon witness slow to accept there was a problem with what they did. Fujitsu only accepted a moral responsibility to the victims of this scandal in late January 2024, coincidentally a few short weeks after the showing of Mr. Bates. And contrition now for some feels self-serving for many CPs. Another in a long line of manoeuvres in brand management, defence and damage limitation. This scandal could not have happened if either Fujitsu or the Post Office had acted on the appreciation that Horizon was not infallible and had listened when postmaster after postmaster told them there was a problem. Without errors by both and clear failures in the oversight exercised by government, this scandal would never have happened. For this story is also about poor decisions in government. The inquiry might conclude that in dodging important strategic decisions about the future of the post office network in a digital age, government kicked the wrong can along the road. They left the wrong people in charge at a time of existential crisis and sowed the seeds of this disaster. When things had plainly gone horribly wrong, they were slow to step in for reasons of political expediency. In this, the biggest miscarriage of justice in modern legal history, transparency and accountability really matter. After years of obfuscation and denial, this inquiry has served to bring some clarity as to how and why the Post Office came to wrongfully prosecute hundreds of its own people. And with that, we now turn to the first subject of these submissions, an important characteristic, we say, of the events that this inquiry has been concerned with, that being really an overarching theme of the story of this scandal, the unblinking defence of Horizon. The response to any question over the integrity of Horizon was defensive. Defensive of Horizon, defensive of Fujitsu, and defensive of the Post Office. Phases 5 and 6, taken together, provide months of shocking evidence on the actions taken year on year that would keep the truth about Horizon and the Post Office's mistreatment of postmasters out of the public domain. And in this section, we suggest 10 propositions the inquiry might consider in respect of the Post Office response to concerns about Horizon and unsafe convictions. Firstly, the unblinking defence of Horizon did not start in 2013 after Second Sight. Instead, the defence of Horizon was only doubled down on, to use Mr. Cameron's words, in 2013. The business knew from rollout that if the Post Office was but to survive, its ethos had to be horizon-centric. There wasn't a plan B. From the apparent ignorance or ignoring of the warnings in Jeremy Folks' Red Flags to the Business, which was commissioned by David Miller, to the critical failure to engage with the joint expert report in Cleveland's, everything in the first days of Horizon pointed to the prospect of it going wrong, being too big a reality to face. Consequently, it was never faced. The inquiry has good grounds to be sceptical as to whether the troubled early history was forgotten or instead a blind eye was willfully turned in the face of growing evidence. The evidence of phases 3 and 4 demonstrates the continued refusal to countenance any message that the operation of Horizon and the approach of Post Office to the investigation and prosecution of its own people was worthy of concern. One only needs to look at the Ismay report in 2010 to see that this was an approach that was set well before 2013. Secondly, independent technical interrogation of Horizon was dodged time and again. Opportunity upon opportunity to consider and conduct a full independent investigation was passed over before the engagement of Second Sight. It was a lose-lose prospect for Post Office, and so it never happened. In truth, recommendations for independent investigation of Horizon as a system went ignored or were allowed to drift. Third, any independent view was to be ignored, dismissed, avoided or diminished. Any critical or potentially critical external view on Horizon delivered to the Post Office was forgotten, ignored, dismissed, avoided or diminished. Alternatively, its circulation was limited with the very real prospect that it was hidden. And it is, we say, sir, striking that documents that really damaged the business view on Horizon had very limited circulation. The inquiry has evidence of the role played by Fujitsu from Paul Patterson. The inquiry also has the evidence of phases 2 to 4. Fujitsu undoubtedly did not pass on everything it should to Post Office in the way it should, and the handling of the EPOS task force is a case in point. Where bugs were passed on, they appear to have been consistently dismissed or explained away as fixed or not relevant with limited questioning. And this was precisely how it appeared the bugs considered in the Second Sight interim report had been handled long before 2013. Moreover, Ernst & Young raised the flag on remote access in 2011 and continued their work into 2012. Alice Perkins was full of apology that she didn't get to the bottom of what was going on. Yet, at the start of her tenure in September 2011, Angus Grant at Ernst & Young appears to have given her an idea. Jotted down in a Post Office notebook with the prescient legend, "We do not see things as they are, we see them as we are," she recorded, "With Fujitsu, Post Office drove a very hard bargain on price, but they took back on quality/assurance. Horizon is a real risk for us." Days later, as Miss Perkins recognised, Donald Bryden, chair at the parent Royal Mail Group, RMG, was questioning what he'd read in Private Eye about Horizon. Even if, as suggested by Miss Perkins, Ernst & Young's concerns were for the past, which were patently not the case. This was a glaring warning that perhaps there might just be something in the Postmaster's claims that Horizon lacked integrity, but nothing was done. And the appointment of Second Sight was apparently a sea change in the attitude at Post Office, and it ought to have been. Yet the business plainly saw the appointment not as an opportunity for rigorous interrogation of Horizon, an honest reflection on Post Office's own past practices, but instead as a means of shutting down press and parliamentary pressure. When Second Sight weren't man-marked by Susan Crichton in the way Post Office expected, they had to go. And the handling of external inputs from experts after the Second Sight interim report is a sorry tale. After Second Sight, the whole business ought to have been on alert. But it was not, because instead it was on the defensive. It will be for the inquiry to conclude whether to accept incompetence truly did ensure ignorance. but we urge scepticism. The actions taken in the post-2013 period invite close scrutiny. Unblinking in its defensiveness at best, it appears that individuals shut their eyes to information which didn't suit the narrative. At worst, they may have buried it, and the greater the opportunity for dots to be joined, the less credible the claims of incompetence or ignorance. The handling of the Clark advice of July 2013 is another shameful case in point, and we spend a little time on that because of its importance. The Clark advice was plainly seen by many lawyers for the Post Office, both internal and external. It went to General Counsel and to Bond Dickinson. Its significance is plainly understood from the outset, with Gavin Matthews from Bond Dickinson and Susan Crichton discussing potential liabilities for Post Office, Fujitsu and Cartwright King as a result of Mr Jenkins' failure to comply with his obligations as an expert witness. The information in the Clark advice ought to have gone to the board and directly to the CCRC in July 2013. There were plainly cases within Post Office's knowledge where horizon integrity had been in issue. Had a proper inquiry been conducted, consistent with the duties of Post Office, then a range of other exculpatory matters may have been discovered. It might have included that Mr Jenkins had not been properly instructed before each case by the Post Office, their legal team or Fujitsu. They would have arguably discovered Mr Jenkins' far wider knowledge of bugs, errors and defects relevant to Horizon, including in its development, and knowledge of Kells and so on. Further, on examination of his earlier witness statements, it would be, we say, inevitable that the trail of edits relating to Mr Jenkins' statement in the Thomas case would have been discovered. The advice should have been disclosed without delay. Instead, the narrow focus of Cartwright King and in turn the Post Office fell horribly short. The inquiry has numerous examples of this narrow focus. To take one, the inquiry has the advice of Andrew Parsons on the approach to Helen Rose report as disclosed. Limiting disclosure and downplaying the significance of a document which, if disclosed without redaction, could have exposed the position of Mr Jenkins was what Mr Parsons advised in relation to the Helen Rose report. We know that sufficient information was passed to Paula Venables and to Alice Perkins so that they were or ought to have been aware of the substance of the advice of July 2013. Ms Crichton's recollection of dates was unclear, but she testified that she would have briefed Ms Venables on the Cartwright King advice sometime after they advised at the London office. Ms Venables conceded that she would have known about the problem with the Fujitsu witness at least a month before September 2013 and definitely in July. She insisted that she never saw the advice and never had its full implications explained to her. On her own explanation as to what she knew, we suggest it is simply incredible that she did not ask to be fully briefed about such an important topic. Similarly, that Miss Crichton and Mr Oljard and then Miss MacLeod all proceeded in the tasks that they did without ensuring the full understanding of the Chief Executive Officer as to the serious implications of this revelation for the business appears simply incredible. The inquiry would determine whether the suggestion that no request was ever made for a briefing or a copy of the advice is credible or merely convenient. Miss Perkins asserts that she was unaware of the Clark advice until much later, that is during the appeals. She said it ought to have been provided to her by Miss Crichton, and she said, quote, "I see this as one of a number of failed turning points in this very sorry story," unquote. Yet it's Miss Venables' evidence that she told her chair what she knew. We observe that this appears supported by the unsafe witness email of the 21st of October 2013. This has to be, at best, one of the most egregious examples of reckless incompetence on the part of each of the players. And the board was updated at the disastrous meeting of the 16th of July, whilst General Counsel was held outside. The board had a paper, including Appendix 1. It didn't deal with the tainted witness. But whatever the board was told, it caused sufficient concern for wrongful prosecutions and the liability of Post Office and its directors asking for a briefing on the insurance position and tasking the team to update the insurers. Did no one in that meeting or any later meeting ask to talk to the lawyers directly about what exactly triggered the real risk to the business? And were there no repercussions for the board members who failed to ask such questions? The following things did happen. Members of the board were told that there was a need for a new witness. They knew this conversation was going on against the background of years of challenge to Paul's historic prosecutions. Did no one really ask, why now? What's wrong with the one we used to use? Again, is this incompetence, or might the absence of any question suggest that the reason had already been explained, even if not recorded? And the inquiry heard that the board continued to be involved in conversations on changing policy on prosecutions and on prosecutions being paused. The suggestion that during this time there was no discussion of the true reason why the pause had become necessary, again appears incredible. And whilst the plight of postmasters was conspicuously ignored, we know the issue triggered a series of inquiries about insurance for directors and officers' liabilities and notification to the board's insurers. The inquiry might conclude that there was much too great a focus on the possible civil liabilities of the Post Office and its directors, and scandalously little regard had for the impact of the serious miscarriages of justice which had occurred for postmasters. Fourth, public relations govern the public interest. Any concern about Horizon or the safety of prosecutions was met first with concern for the business and its public perception. Whilst those in corporate control of an organisation must have concern for its brand, reputation and public relations, evidence before the inquiry was of a Post Office wholly driven by a desire to protect the brand, its message and commercial interests to the exclusion of all else. Steps responsive to substantive concerns raised about Horizon or about prosecutions were never about asking the right questions. Is this thing working? Are we in the wrong? Instead, they asked, how do we defend ourselves from this attack? And the Post Office lines on Horizon evolved, but at the core of the business remained a combination of disdain and contempt for postmasters. As examples, sub-postmasters were incompetent or on the take. Horizon was robust. Horizon worked across the network and many, many transactions were absolutely perfect. And it didn't matter what was said. It didn't matter if what was said was wrong if the myth stood. The myth being that Post Office had never lost a case where Horizon was challenged. It didn't matter if what was said was offensive. There were moments when the mask truly slipped. We've been reminded this morning of Mark Davis describing what postmasters were suffering as lifestyle difficulties, which was shameful, of course. But Miss Venables asked the inquiry to believe that she rolled her eyes and said, "Oh, Mark," but only days later, her unguarded late evening post-one show congratulations showed the true position. She said she was more bored than outraged by the plight of the postmasters. Mrs. Hamilton lacked passion, which was a risky remark, and Miss Venables was so apologetic when shown this while sitting in the room with Mrs. Hamilton. Yet in 2014, she was so proud of her team, she copied this to the chair, Mrs. Perkins, twice. Once in the original, and again recirculating her missive the next morning in the cold light of day. The inquiry may be invited to treat these as gratuitous moments of unguarded chat between colleagues under pressure. Instead, they paint a telling picture of the true story. Fifth, the message from the top was, I need to know all is well, so tell me what I need to know, tell me what I want to hear. And that was seen in February 2015 before Mrs. Venables' appearance before the Select Committee when she said, is it possible to access the system remotely? We are told it is. What is the true answer? I hope that it is that we know that this is not possible and that we're able to explain why that is. I need to say, no, it is not possible, and that we are sure of this because of XX, and that we know this because we have had the system assured. Litigation privilege and secrecy in all its forms was overused by the Post Office. The inquiry's heard a lot about concerns for privilege within the Post Office, and it underlines the criticism made of Post Office by Mr. Justice Fraser. And the inquiry will remember the circular from Ms. Springford in the face of the Shoesmith's letters before claim. Your staff should therefore think very carefully before committing to writing anything relating to the above issues which is critical of our own processes or systems, including emails, reports or briefing notes. Lawyers for Post Office were very quick to assert that this was standard commercial litigation practice, but it wasn't, and Roderick Williams effectively conceded as much. 7, the Post Office did not respect obligations as a prosecutor or its duties to the court. By way of contrast to the very assiduous approach taken to privilege, it appears that there was very little understanding or little respect for the duties of Post Office as a prosecutor, including the continuing duty of disclosure. It's plain that Post Office were advised in the Clark advice and in the advice of Brian Altman, King's Counsel, both of which were predicated on the prosecutorial duty. However, the inquiry may wish to consider whether the business ever understood, respected, or took ownership of that duty. When this duty was spelled out for the business, it was, coincidentally, once again, restricted in its circulation. Those who sought to understand and had a responsibility to do so ought to have done better. It appears that successive lawyers failed to appreciate the scope and implications of the continuing common law duty of disclosure or approached it in an unduly narrow way in its application. General counsel such as Susan Crichton, Chris Ojard and Jane MacLeod and Bond Dickinson all ought to have understood the duty by virtue of information provided to them by Cartwright King or Brian Altman, and will return to consider the position of regulated legal professionals shortly. When problems were escalated through the business, as my 8th point, there was a wholly inadequate response. When issues were escalated, no one acted as they should. When information which should have changed the path of this scandal crossed the desk of anyone at the Post Office, the response fell short. We've already dealt with the 2013 Clark advice, but we now deal very briefly with Project Zebra and the Zebra Action Summary. Because the handling of Deloitte is a paradigm example of Post Office's approach to external expert input. The Zebra project was, of course, so closely guarded when all it was doing was looking into whether or not matters such as remote access were possible. But it was so closely guarded that when disclosure was eventually given, the name remained redacted for privilege. Hence, the comments on the absurdity of the approach to privilege from Mr. Justice Fraser. And we ask again, why is it that documents that were fundamentally problematic to Post Office just happened to have a very limited circulation and ended up not being properly escalated? Because Project Zebra resulted from advice to the board from Linklaters designed to satisfy the board that all was well. The work was to expressly consider data integrity. And the Zebra Action Summary, eventually disclosed into the GLO, shows that the business was plainly aware of the Deloitte work for the integrity of Horizon at this time and didn't just become aware of it when Jonathan Swift QC, as he then was, pointed it out. The report, the board summary and the action summary contain very important information about remote access and the integrity of data, and the action summary is very clear that essentially remote access was possible in an undetectable way. That was there in 2014. It wasn't disclosed. On Zebra, Miss Ojard may point to Mr. Ojard rather may point to Miss Sewell, and Miss Sewell may point to Mr. Ojard. Mr. Ismay, again, who wrote the whitewash, which of course covered integrity issues and to whom we'll return shortly, was again in the mix. the inquiry may conclude that questions of accountability must be considered for all. This was yet another seemingly missed or maybe dodged opportunity for things to have gone so very differently. It ought to have been disclosed in 2014, and certainly no later than 2016, when the question was raised by Jonathan Swift. 9. The hardened, beat-all defence of Horizon of Paul of the individuals involved presented any notion of true accountability and have infected the approach to both the mediation scheme and the GLO. The defend at all costs attitude that we've seen in the previous 8 points, the failure to disclose things, the failure to let people know about the problems, that attitude calcified and hardened the approach of the Post Office to every step in this scandal. This included the mediation and the conduct of the GLO. Again, the evidence heard by the inquiry fully justified the criticisms laid at the door of the business by Mr. Justice Fraser. And 10th, and finally, Fujitsu supported Post Office till the end. We addressed the role of Fujitsu in support of the actions of the Post Office in phases 2, 3 and 4. We don't repeat those submissions here, but we reiterate that while the decision-making of Post Office was front and centre in the final stages of this inquiry, Fujitsu's role remains critical. All of those 10 points were part of the unblinking defence of Horizon by Post Office as a theme running throughout this inquiry. Now, the second of our topics, investigation and prosecution. We don't revisit our lengthy and detailed submissions made at the close of Phase 4. We repeat them and adopt them and summarise them briefly, now so if we may. First, the approach of the Post Office, supported by Fujitsu, to investigation and recovery of losses, as well as prosecution of alleged offences, was deeply and fundamentally flawed. Second, the management and oversight of investigations and prosecutions by the Post Office, as supported by Fujitsu, was willfully blind to or disregarding of the proper, lawful administration of justice. Thirdly, and finally, an overarching focus on the commercial interests of both the Post Office and Fujitsu, including in protecting the brand reputation of both companies, contributed significantly and detrimentally to the prosecution of individuals in the face of faults in Horizon, of which the Post Office were or ought to have been aware. Since Phase 4, we've had further evidence about investigation and prosecutions over the summer and autumn in Phases 5 and 6. That evidence confirms that the approach of Post Office to prosecution was fundamentally flawed. It was built on a toxic premise. It was run by those who were incompetent, ill-trained, under-supervised and overly aggressive, and ultimately motivated by commercial and/or personal interest. There were structural and individual failures in investigation and prosecution at the Post Office from the start. While focus may principally have been on Mr. Bradshaw and on Mr. Singh, there remains considerable concern that the action of others, including those who did not give evidence, ought not to be overlooked, whether for criticism by the inquiry and or some other outcome. Examples of poor conduct pepper the evidence. One example is found in the interview of David Blakey, covered in the evidence of Paul Whittaker. There were first unfounded insinuations of an affair, then the implicit threat that continuing to resist the allegations of Post Office would result in the interview and the investigation of his ill wife. Another example is the questioning of Lynette Hutchins by Gary Thomas, accompanied by Graham Brander, as to why they had retained Izzy Hogg as their solicitor instead of a local solicitor. Miss Hogg had first defended Joe Hamilton and went on to represent a number of other postmasters who raised concerns about Horizon when they were prosecuted. She believed in the postmaster's cause at a time when it was not a cause célèbre. She was plainly a thorn in the side of Post Office, and that question should never have been asked. Miss Hogg died on the 26th of November this year after living with cancer for a long time and living every moment of what life was left to her to the full. And so we pay tribute to her courage and integrity. And we anticipate that such prosecution files that remain available and subject to complaint by individual postmasters have been passed not only to the inquiry, but to the Metropolitan Police Service. We spend no more time on this now, but turn to where we are now, where the Post Office has learned enough from the past to make proper change. We make a number of observations on this. In order to consider whether the Post Office has learned the lessons of the past, the inquiry must consider how its approach to investigation and prosecution has changed. First, we underline that while much store was placed in the decision to stop prosecutions in 2014, this was not a swift full stop. We note that there appeared to be at least some evidence of a discussion of return to prosecution as late as 2019, and we say that the Post Office should never be permitted to pursue private prosecutions in their own right ever again. The evidence about self-reflection in Phase 7 is deeply disappointing. It appears that this work was prompted only by the work of this inquiry and the evidence of postmaster core participants on human impact. And we note that Project Phoenix was only concluded in August 2024. And Post Office employees were supported to come before this inquiry to give evidence when they were working in roles which essentially led them to have direct contact with postmasters when they were seeking redress. The process of ensuring that that didn't happen has taken way too long, and the suspicion must be, sir, that this process of self-reflection didn't really matter to the business until it had the potential to embarrass senior management during the coverage of this inquiry. Third, whilst a renewed commitment to whistleblowing appears positive on paper, in practice the inquiry might be concerned that the commitment is hollow with all the different investigations that have gone out and then come back in with nothing resolved. Fourth, and most importantly, a true change in approach is unlikely to occur until the toxic attitude of disbelief and distrust in postmasters, and especially as seen with the postmaster non-executive directors, is made a thing of the past. And finally, there is scope for learning beyond the Post Office in this inquiry. While the Post Office may have stopped pursuing private prosecutions, there are a number of bodies which have pursued and continue to pursue private prosecutions. We invite this inquiry to recommend government conduct a review of the operation of private criminal investigations and prosecutions within the UK, focusing on both public and private bodies who pursue these activities outside of the ordinary activities of the police and CPS. And the House of Commons Justice Select Committee previously recommended that an inspectorate for private prosecutions be created. This would have included the introduction of a binding code of standards. These proposals were rejected by the government, but we invite the inquiry to revisit these recommendations and associated safeguards and to urge government to establish an inspectorate of private prosecutions without delay in order to try and ensure that no repetition of this scandal can ever occur. We turn now to our third topic, the role of regulated legal professionals. Whether working in-house or at Post Office or acting for Post Office when based externally in firms and chambers, regulated legal professionals might be expected to provide the requisite independence to rein in a blinkered corporate resistance to criticism. But this scandal all too often saw both internal and external lawyers form an integral part of the robust defensive horizon and the civil and criminal proceedings which were founded on its corrupt data. All too often, lawyers were seen to fight a rearguard action for Post Office, whether they were involved in civil proceedings, criminal prosecutions, reviews of convictions, or the group litigation. We've touched on some examples of this in our written submissions. We won't expand too much, sir. But firstly, the civil proceedings. The early proceedings which led to the bankruptcy of Lee Castleton are informative of the approach which was to be taken by Post Office throughout this scandal. It had nothing other than a vindication of Horizon to gain from fighting to a conclusion against a man who was experiencing health problems. They should have settled, but they didn't, and forced a conclusion in their favour. But it was the response to the Shoesmiths litigation that saw the real doubling down, and the real foundations for the inexorable outcome that Paul's legal strategy was to become as much a part of the robust defence of Horizon as the actions of its PR-driven executive and its mafiosi investigators. The advice from Emily Springford became the orthodoxy within Post Office, and echoes of this guidance can be found in the advice offered by Bond Dickinson in the aftermath of the Second Sight interim report and beyond. And until the Clark advice of July 2013 shattered forever the smug triumphalism of Post Office prosecutors, epitomised by the bandwagon email from Jarnail Singh at the conclusion of the trial of Seema Misra, no lawyer in Post Office had ever turned their mind to whether such an approach, in terms of privilege, created issues for the prosecutions conducted by RMG and Post Office. In reality, if John Scott shredded notes of the review meeting and ordered that no notes be taken other than by him or his department, he may only have been acting in accordance with long-standing practice. In criminal prosecutions, the treatment of the evidence of Gareth Jenkins as an expert witness is almost inconceivably poor, that none of the lawyers involved in deploying his evidence realised at the time that Gareth Jenkins was acting as an expert witness and therefore should be guided as to his duties as an expert and properly deployed by them as such is difficult to believe. Additionally, the approach to disclosure was very often flawed. Post Office, whether through its internal or external lawyers, and whether in respect of third-party disclosure concerning Fujitsu or response to defence requests, failed so often in its disclosure duties. Mr Singh described disclosure requests by Mrs Misra's legal team as unreasonably and unnecessarily raised, completely in keeping with the robust defence of Horizon. On reviews of convictions, Post Office announced that it had instructed an independent firm of criminal specialist solicitors to identify every criminal case prosecuted by Post Office and Royal Mail Group prior to their separation. As Simon Clark accepted, that was not accurate. In fact, it was positively misleading. Cartwright King were not independent. Only weeks before they were appointed as an independent firm of criminal specialist solicitors, they had secured a PII certificate with the stated objective being to protect the reputation of Post Office. They had been prosecuting the very cases they were looking into. They were marking their own homework. And if a truly independent firm had been commissioned to carry out the review, it may be that the full substance of the Clark advice would have been disclosed in appropriate cases, as Brian Altman conceded that it should have been. And the group litigation, finally. The GLO saw the continued aggressive defence of the position of Post Office by internal and external lawyers. That Mr Justice Fraser considered it necessary to refer to the litigation strategy adopted by Paul in his judgment in the terms that he did is a measure of how apparent that approach was. The application to recuse the trial judge and the subsequent appeal against the refusal of that application were, in reality, entirely consistent with that strategy. In summary, issues of independence, conflict and competence arise throughout the evidence of the legal professionals paid to support Paul through this crisis. And the inquiry might conclude that this evidence taken together makes a strong case for the more effective regulation of both professions. It may wish to call for a substantial change to the guidance which the SRA and the BSB provides to solicitors and barristers on the dangers of losing independence. Our fourth topic now, that of management, governance and oversight. We take this briefly as we've dealt with it in detail in our written submissions. First, pre-2013, second, post-2013, and then some themes in the evidence. Pre-2013, plainly, failures in governance were not limited to the period post-Second Sight. The Cleaveley's case study reaches significant conclusions about the weaknesses in governance at Paul and RMG in the period around 2004. There were plainly other failures, whether in communication, failures to exercise curiosity or to act on obvious indications of risk, which directly contributed to the making of this scandal or which were obvious missed opportunities to avert it. David Miller, who signed off the Cleveland settlement, had been programme manager for Horizon. The same Mr Miller now accepts they ought not to have told the Post Office Board before acceptance that Horizon was robust and fit for service. The failure to act in response to the growing recognition of problems in the context of ongoing proceedings at the same time as the Castleton proceedings evidences continuing failure. And by March 2006, Keith Baines was being copied in on important correspondence regarding expert evidence on prosecutions. Almost at the same time, he was coordinating with Mandy Talbot and highlighting the issues raised in the Thomas case and others for Castleton. Whether aware of the Cleveland's and/or Castleton reports or not, this discovery, both of the position of Mr Jenkins and that Paul was actively seeking to doctor supposed expert evidence, ought to have been escalated up the executive line and beyond. Against the background of the Cleveland's and Castleton experiences, it ought to have been a clear indicator of a problem for both Paul and Fujitsu in their approach to Horizon integrity and the supportive proceedings against postmasters. And the shutdown of proposals for an independent investigation in March 2010 is familiar to the inquiry. Again, we see both Ms Tolber, Mr Ismay and Mr Scott playing a role in this conversation alongside Mr Wilson. And in 2011, the first sub-postmaster letters before claim arrived. One of them was on behalf of Scott Darlington, who's in the room today. And these were being run under the RMG legal team with the advice on privilege circulated by Emily Springford in October 2011. The Ernst & Young work done on integrity went nowhere. And the inquiry is invited to treat with scepticism any assertions of those in leadership, whether at Post Office or Royal Mail Group, of ignorance of the prosecuting function of the Post Office or the continuing question of Horizon integrity. Mr Miller, for example, was clear that he understood that function and the role of RMG Legal when part of the executive team before he retired in 2006. At each of these stages, there were commercial incentives and imperatives to look the other way. In 2005, Impact was being rolled out. By 2006, plans were beginning for Horizon Next Generation. The board wanted it to be cheaper, and the planning was discussed by the board, both at Post Office and Royal Mail Group. These provided the foundation for cheaper operations and the growth of network banking. No one appears to have considered the operational experience for the postmaster. Post-2013, there are numerous failures of governance illustrated in the two case studies in 2013. We don't repeat them, but there were further problems beyond the case studies. Those failures must be viewed in the context of a history of years of defensive retrenchment on the part of the leadership of Paul, a toxic culture of anti-postmaster feeling, which carried into every aspect of Paul's engagement with the issue of Horizon integrity. And the evidence, included as analysed in both case studies, supports the conclusion that precisely those who had the opportunity to halt this scandal, the chief executive, the chair and the shareholder, singularly failed. The themes we identify in terms of governance are perhaps wrongdoing, willful blindness, incompetence or inertia, board effectiveness and the role of a shareholder. There are clearly issues to consider under wrongdoing, willful blindness, incompetence or inertia about the state of mind of those involved in making decisions. So far as board effectiveness is concerned, the inquiry may consider issues of overboarding, whether or not directors had sufficient guidance and training, and whether or not board effectiveness reviews are sufficient to ensure that public companies are able to function properly. And finally, in this section, the role of the shareholder. The inquiry may recommend that UKGI take ownership of the failings of the successive non-executive directors in this process and accountability for the failures of oversight afforded by government generally. There ought to be a serious process of reflection within UK GI and government more generally as to the effectiveness of the safeguards in place for the management of risk in government assets, taking on board all of the learning in this inquiry and its conclusions. We turn now to our fifth, penultimate and quite short topic, redress restorative justice and rebuilding trust. As said earlier, the impact on postmasters and their families affected by this scandal has been life-altering. Full, fair and prompt compensation has been the touchstone commitment repeatedly given by ministers in the Post Office since 2021. From its outset, this inquiry has consistently asked whether those twin goals of full and fair compensation could be delivered promptly. Compensation has not been prompt. For many, it's also so far been neither full nor fair. In our written submissions, we've identified a number of difficulties with the operation of each of the schemes. There's no time to mention those problems now, but problems persist with each. And all of those failures contributed to cause delay and to undermine the trust of postmasters in each of these schemes. For many, the re-traumatising impact of making a complaint is confirmed in expert evidence. Put simply, many awaiting compensation continue to live in poverty. Many are ageing and desperate to move on, and these vulnerabilities should not be ignored or exploited. And it seems that many problems have only been addressed once the inquiry has asked Post Office to address them. The inquiry is invited to consider whether a more fundamental shift in approach by both Post Office and the Department is necessary to secure the confidence of postmasters and the wider public in the continuing process. On restorative justice, we welcome the indication by the Minister and by Fujitsu that they would be open to engaging with lost chances for sub-postmaster children. A more innovative and open-minded approach to restorative justice for those impacted by this scandal is well warranted. And to conclude on redress, we suggest that this is a scandal founded on flawed corporate culture and repeated corporate failings. Where the actions of the state harm its citizens, there must be a moral obligation to see justice as more than simply an opportunity for good press or political popularity. The state must accept that when it's wrong and its citizens are damaged, the value of compensating those who suffer must be measured in more than solely pounds and pence. And this is a lesson which appears long overdue. It ought to have been learned time and again in previous schemes. It is one which ought to be marked in this inquiry. This injustice cannot be undone, it cannot be forgotten, and redress for all may start to rebuild trust for some, but no postmaster will truly be able to move on, nor can the Post Office even begin to be rehabilitated in the public consciousness until that's achieved. And we turn now to our final topic, where are we now? When Mr Reid gave evidence to the inquiry on the 11th of October 2024, he recognised that securing a replacement for Horizon should be something that Post Office should quickly deal with. On the 4th of December 2024, the Daily Mail reported that Post Office had dumped plans for introduction of NBIT. Instead, Post Office had agreed a one-year extension to its Horizon contract with Fujitsu. And whilst the new deal for postmasters was trumpeted on the 13th of November, it's now 5 years since the Horizon Issues judgment conclusively established the unreliability of the system. It's now 3.5 years since the judgment in Hamilton and others, and there still appears to be no firm plan for the replacement of Horizon. Progress has been too slow in that regard, and progress has been too slow in too many regards. Mr Cameron suggested that NBIT and its management had problems which were both structural and individual. He and other witnesses agreed that the funding rounds of central government were necessarily not suited to a dynamic business or the planning of longer-term commercial projects. However, he also appeared to accept that the failure to grapple with this scandal went back to the failure of management during separation. And the inquiry might also consider that the roots of this scandal lie in a bigger question, tied more inherently to a more fundamental schism in the Post Office, in an unhappy marriage between the public and the private. At the inception of Horizon, the Post Office was in existential crisis. looking into the future to a very different business model to support the move away from a network supported by a closed market in benefits collection. As the pension book system was ripped up, successive governments sought to both maintain the community model for the post office and at the same time impose a more commercial, efficient operation designed with a long-term goal to reduce reliance on public funds. Yet, through all the projects and all the strategies up to network transformation and beyond, it must be asked whether anyone really considered whether a successful commercial operation would or could operate on the same model as a network designed to preserve a nationally valued community resource. The tension between these goals runs through the evidence before the inquiry. In failing to grapple with this problem effectively in 1999, and again and again and again throughout the last 25 years, it might be said that successive governments contributed to the position of crisis and commercial hunger, which drove the post office as an institution and individuals within it to lose sight of the true value of the network and the individuals within it. The focus of all in 2013 on the future of Post Office as a freestanding entity with an eye on mutualisation as Royal Mail passed into private ownership was plain in the evidence of Ms Venables and Ms Perkins. If Horizon were to fail, mutualisation, the public goal for the future of a commercially viable post office, would be impossible. Post office strategy is a problem with which this government and any that follows must grapple with honestly. A truthful strategy that understands the value of the network to the communities we live in now must be the starting point. What happened to the postmasters can never be allowed to happen to others again. It is simply not acceptable for decent, hard-working people of good character to be collateral damage in the pursuit of commercial imperatives. Their value must be recognised. The value of what they do must be recognised. High net worth should not just be viewed as how much money a person has. It should be measured by what worth the person is to the community in which they live, the contribution to the lives of others, to education, to healthcare and security. In communities across this country, the role of postmaster is of high net worth and now needs to be treated accordingly. And although Post Office refused to hear the concerns of postmasters and dismissed them as subbies with their hands in the till who lacked passion and had lifestyle problems, this inquiry has listened intently to them and the evidence of the reasons for their plight. They are uniformly grateful for that now, and now await the findings and recommendations of the inquiry.
Thank you, Mr. Maloney. It's now just about 1:05, so we'll resume at 2 o'clock.